at the court to prepare to witness today's proceedings. Already just a few minutes ago, the General Secretary of the NDC, Mr. Johnson Ketia, arrived, also went through the COVID-19 protocols here at the Supreme Court before making his way into the courtroom. You will recall that Mr. Johnson Ketia is one of the witnesses for the petitioner, and we have more of the spokespersons on the second respondent's side arriving, and that's one of the lawyers, Faisal, just also making his way to the Supreme Court at the moment. I'm sure he will be preparing to come inside the court premises in a jiffy as well. We've seen the lawyers on both sides also arrive with their documents much earlier. Their aides came in with the documents that they intend to back their case in court, especially this morning. You will recall that the last time the court sat, it dealt with the issue of an application that had been brought before it by the petitioner's lawyers. The application sought to ask the court to permit the petitioner to inspect some documents that were in the possession of the EC. And that, of course, was dismissed by the court. One of the major reasons the court gave was that the petitioner already had in his possession the same documents, copies of the same documents he was asking for, really. Some of the spokespersons for the legal team of the petitioner, Mr. Eduji Tamaklu, as well as Mr. Ibrahim Amaliba, making their way to the court right now. Thank you very much, lawyer. But so today, what are we likely to see? There are indications that your side might present a third witness in the person of Mr. Rujo Metal Nunu. Is that the case?
That's certainly correct. As you're aware, yesterday we have filed our witness statement for him. So most likely today we will be dealing with that issue.
And so Mr. Rujo Metal Nunu's name came up, especially during the cross-examination of Dr. Pesa White. What are the issues that he will be seeking to bring the court's attention to?
Well, the witness statement is out there. I've seen it on social media. I was surprised it came out, but the details are out there. I do not want to preempt exactly what is going to happen in court, but as you have seen, his name kept coming up, and he happens to be one of the agents of the petitioner in the EC strong room, and so his testimony is quite crucial to a lot of the determination that will happen.
Again, so you talked about the information being out there on social media. We have cited that information as well, and portion of it seek to suggest that he was misled by some EC officials.
I don't want to go.
I respect that. I respect that. Madam Joyce Bawa Muktari is the spokesperson for the petitioner himself. In this case, he was the candidate during the 2020 elections. So as we prepare to witness what will happen in court today, what are some of your expectations? We are getting indications that the petitioner's third witness in the person of Mr. Rujo Metal Nunu will be in the box. Is that the case?
Yes, please. Yes, please. He has actually filed his witness statement, so certainly the court will be taking his deposition today. I have no doubt that the petitioner has a good case, that indeed, considering the inconsistencies, considering the mistakes, the errors that the EC itself has since admitted to, the petitioner has every reason to institute this course of action. I'm sure that we've all listened to the General Secretary, we've listened to Dr. Pesa White, and today, of course, we'll be taking the witness statement by the Honorable Rujo Metal Nunu. And I'm sure in the next few days, the lead counsel, Mr. Chachi Chikata, will be cross-examining the EC Commissioner herself, the returning officer. I am looking forward to us convincing everybody that the EC indeed did not work in accordance with its constitutional mandate, and that the petitioner deserves, if for nothing, one, a rerun as he requests in his reliefs. Secondly, that the general public must know. And thirdly, that we should ensure that no future returning officer of the EC can undertake to make such corrections inadvertently, suo motu, without due consideration to the other parties.
Honorable, without seeking to preempt what will happen in court today, will allow you to go so that when sitting is over, we may be able to analyze whatever transpired in court. Thank you very much. And that was Honorable Joyce Bawa-Mukhtari. She was a former Minister for Transport, but also spokesperson for the presidential candidate of the NDC in the just ended 2020 elections, former President John Dramani Mahama. You just heard from her as well, expressing optimism about what is likely to happen in court today. And the national chairman of the New Patriotic Party, the party on whose ticket the President Nana Addo Dankwa Akufo-Addo stood for the 2020 elections, is just arriving. Honorable Freddie Blay, Chairman of the New Patriotic Party. Honorable, very good morning to you. This is JTV. So we understand that this morning the petitioner's third witness will be in the witness box. What are some of your expectations?
It's too early in the day for me to have expectations. We want to see this petitioner's case and is bringing his witnesses, and I don't want to speculate on that.
I respect that, sir. Thank you very much. But we hope to speak to you right after the proceedings. That time it would have been clear. And that is the national chairman of the New Patriotic Party, Honorable Freddie Blay. He says he does not want to preempt what will take place in court, but has made a promise to speak to us after the proceedings. And so just as a quick reminder to those of you who probably have not been able to follow proceedings from day one, but I'll just quickly remind you of what happened basically on the last day the court sat, and that was on Wednesday, the 3rd. The petitioner sought to inspect some documents that are in the possession of the second and the first respondent, I beg your pardon, and that is the EC. That application, of course, was dismissed. Mr. Samuel Wuku, who is the organizer of the New Patriotic Party, just got down off his car a while ago, made a call, and has returned to the car. Well, it remains to be seen if he'll be coming down anytime soon, Mr. Wuku. Okay, so he drives by. I'm sure he will be in court today as well. You'll recall that during the 2012 election petition, which actually took place in 2013, Mr. Samuel Wuku was one of those who was charged for contempt of court. Fortunately, he was not one of those who were jailed briefly, but he was charged, given a warning, and asked to be of good behavior. So far in the 2020 election petition, no issues of contempt have come up as yet. I'm sure many persons involved in this case, supporters of both the petitioner and especially also the second respondent, probably have taken a cue from what happened in 2013 when the 2012 election petition was being heard, and all the repercussions of some of the very negative comments they made about the court. And so maybe lessons may have been drawn from all of these, and the people supporting these parties, the petitioners party, in this case the NDC, and the second respondents party, in this case the MPP, have been very, very cautious with their commentary, at least so far, and the court hasn't had cause to complain, except to say that lawyers who have been named as part of the legal teams in court should desist from making commentary and from addressing press conferences after each court sitting. And the court last week especially singled out Mr. Frank Davis and cautioned him to desist from granting any further media interviews, particularly because he is a member of the legal team of the second respondent. And since then, Mr. Frank Davis has not addressed the media. In his place, the Minister Designate for Information, Honorable Kojo Oponkroma, has been the one addressing the media, and supported by Nana Boache, who is also a lawyer and currently one of the deputy chief executives of the National Service Scheme Secretariat. So we are waiting for the arrival of some of the key persons in this case, but as I've already indicated, the General Secretary of the NDC, Mr. Johnson Esedin Ketia, is already in court. The Chairman of the MPP, Mr. Freddie Blay, is already in court, and Baba Jamal, a leading member of the National Democratic Congress, making his way to court now. Baba is one of those who addresses the media, and we were sure that after the sitting we'll get to speak to him as well. He has just made his entry to the Supreme Court for preparations for the sitting to begin. Shortly, I will also be giving you a peek into what to expect in court today. Obviously, we are aware that the petitioner's third witness will be in the box. But arriving right now is the chairperson, the chairman of the National Democratic Congress, the NDC's national chairman, has arrived in the company of Mr. Sylvester Mensah. You would recall that Mr. Sylvester Mensah was one of those who attempted to be on the ticket of the NDC ahead of the 2020 presidential elections. Also coming now is Mr. Elvis Efriye-Ankra, former minister in charge of youth and sports. He was a former deputy minister also in charge of local government and rural development. Of course, Mr. Samir Wuku is here. Thank you very much. Good morning to you.
It's been 8 years of
I was just making that commentary to our viewers that 8 years ago, Mr. Wuku. Yes, so we want to hear that from you, Honorable Samir Wuku. And our camera is safe. You can just face the camera and talk to us. Yes, sir.
I mean, basically, it brings memories. And 8 years ago, we were on the side of the petitioners. Today, we're on the side of the respondents. We all just have to be mindful with our communication on what happens in court.
I was just commenting on that when you arrived and we saw you making that call after you got down from your car. And I said that this year so far, the court hasn't complained about anybody making contemptuous comments and so on. You believe that what happened in 2013 has taught all of you who speak for the various political parties a big lesson?
And absolutely, and I think it's also brought some sanity to the way we discuss these matters on air and on TV and all that. But my simple advice is that let's be mindful with how we communicate on these matters. At the end of the day, our lordships, they have the final determination, the final say in these matters. So thank you.
So, thank you very much. We are grateful for your time. And that was the organizer, national organizer of the NPP, Mr. Samir Wuku, talking to us particularly about his own experience in 2013 when he was charged for contempt of court. Fortunately, he did not go to jail, but he says he has learned a lot from that experience and is cautious about comments that he makes. And from day one, Professor Jane Nano Pukwajiman has been in court. She was the running mate to former President John Dramani Mahama in the just ended elections, the elections to which this controversy is all about, and she has also just made her entry to the premises of the Supreme Court. Today's sitting, we're told, on Wednesday will begin at 10, and so in the next 30 minutes we believe that all will be set for sitting to commence. And again, of course, GVC will be here to ensure that you get all the details from election petition 2020. Of course, we also do know that one of the representatives of the NDC's presidential candidate at the EC's National Coalition Center, which is often called the Strong Room, Mr. Rojo Metonunu, will be in the witness box today. He has made some comments. So again, with me in the background is my colleague Barbara Kuma. Barbara is court correspondent, and Barbara has been in court from day one as well. The last time the court rose, it was unclear what the next step would be. It left all of us, even as journalists who are as nosy as we can be, struggling to decipher what would happen next, even when we spoke to representatives of the spokespersons, especially of the spokespersons of the petitioner and the second respondent in particular. None of them could tell us exactly what to expect today, but we're getting indications that this morning Mr. Rojo Metonunu, one of the NDC's candidates, in this case the petitioners' agents in the strong room, will be in the box.
It is likely to be the situation, because as at the last time we rose, we didn't know who was going to come, whether it was going to be the EC or whether there was going to be another witness in the dock. But it is most likely, I'm 99% sure that Mr. Metonunu would be in the dock this morning because of the statement he filed yesterday around 3 p.m. And let's just see what happens today.
Yeah, because what indications we picked in court is that lead counsel for the petitioner, Mr. Chachuchikata, did indicate to the court that one of the petitioner's witnesses was unable to write his witness statement, so to speak, because of ill health. And following that, he requested that they met in chambers, and I believe that we also address some of these issues. These are just conjectures that we can make at this point in time. But for those of our viewers, especially, and it's always instructive to and again, Mr. Gabriel Asari Ochridako is one of the leading members of the MPP, and he's also a lawyer as well. Thank you very much. Without attempting to preempt what is likely to happen in court today, the last time the court sat, indeed, there was they met in chambers, came back, and we really didn't have any indication as to what the next step would be. We are getting indications that the third witness for the petitioner will be in the witness box today. Are you aware of that?
It appears so. Of course, you saw the witness statement that was filed yesterday. So yes.
And as more witnesses are called for the petitioner, that should be a source of worry for the second respondents. And you are a huge supporter of the second respondents, because then this would mean probably that more evidence will be adduced against your side.
Well, I think the council met the bench in chambers, and they all agreed that this was perhaps special circumstances. And I suspect that they won't spring another surprise. But it appears that there were some medical circumstances, as Chikata said in court, Mr. Chikata said in court. So I'm sure there's some mutual understanding, and obviously I don't expect there will be another surprise. Yeah.
And after court, we hope to speak to you about one of your tweets about security for the EC chairperson. But
I believe in it strongly. I mean, really, it is not for you and I to determine for national security how to protect certain important people in our society. And clearly, we all know the pressure that's been put on this woman. So I think we should be a bit more.
Like I said, we'll hope to talk to you after court, so we don't preempt what will happen today. Thank you very much, Mr. Gabriel Asare Ochoda, a leading member of the New Patriotic Party, sharing his expectations with us ahead of this morning's sitting at the Supreme Court. And so the strong indications, indeed, it's almost confirmed that Mr. Ruju Metal Nunu will be in the witness box. Ruju Metal Nunu, and the official name is Robert Joseph Metal Nunu. And so, Barbara, I was just making an attempt so we could begin to take our viewers, those who may not have been following this event on a daily basis, this sitting on a daily basis, but still need to know how far we've come in this journey. Let's go back to the last time the court sat. It had to do with inspection of a request, an application by the petitioner to be allowed to inspect some documents that are in the possession of the EC. The court dismissed this. Quickly, let's summarize what happened on Wednesday when the court last sat.
Well, on Wednesday, counsel for the petitioner, that's the lead counsel actually, Mr. Chachuchi Kata, had filed an application for an order for the production of some document to be inspected by them. That's the petitioner's legal team or the petitioner himself. And so they came to court on Wednesday. He moved the application, argued out his points or their points as to why they wanted those.
All right, so the Minister Designate for Information, Mr. Kojo Nkrumah, making his entry to the Supreme Court. I'm sure he'll go through the protocols as well as he goes through, yes, and he is making, but again, Mr. Kojo Nkrumah is one of those who of late has been addressing the media on behalf of the second respondents legal team. That is after the court singled out Mr. Frank Davis and instructed him to desist from granting media interviews. Again, we have the legal persons making their entry to the Supreme Court. We wish you good luck, sir, and we. Okay, and so I'm still here with my colleague Barbara Kuma as we attempt to put all of this in perspective for you, viewer out there. So, Barbara, we're talking about events of Wednesday, application to inspect documents.
So for the petitioner, his case was that with these documents, they wanted the original documents of some of the forms from 13, from 12, from 9, from the EC. I mean, the EC is the legal custodian of all these original documents. And so they wanted the EC to tender or bring them the documents so they can inspect and then further make, build or make their case however they wanted to. I mean, excuse me, I don't know the way to use, but they wanted the forms so that they could take a compare. That's the exact word they used, to compare their carbonized copy with or to the copies, the original copies from the EC, so they could make their case or build their case from there. But according to the counsels for the second and first respondents, it was not the proper timing. The timing was wrong for them to even be asking for such documents, because if you listen to Justice Lawyer Justin Amenuvo, he said that the petitioner had 21 days to do so, and he didn't do that, or they didn't do that.
And on the day that that application was made, we had traveled 34 days
into the hearing, and it was the 9th sitting, I guess, if my math says me right. It was 9th sitting, and said the timing was just not it for them, and so the courts shouldn't allow that. And by the arguments of lawyer Akoto Ampao, he also made some points about the petitioner trying to shift the burden of proof and persuasion onto the first respondents, since they are in court trying to prove a case. They should rather be doing that and not the EC. And so their application then was misconceived, and if granted would not serve justice to the first and second correspondent, and indeed the country. So that was their case, and the court rose on the matter. They came back and
all right, but currently we're seeing lawyer Yao Opong making his way to court right now. He's one of the members of the legal team of the second respondents in this case, Nana Addo Dankwa-Akufo-Addo, the President of the Republic. Yes, Barbara.
So as we were saying, the 7-member panel came back and said that the petitioner hadn't made any strong point or case for which that application should be granted, and besides, it was not within their right. It was a discretionary subject, and so they couldn't come to court feeling entitled. So they quashed or dismissed the application, so to say. Yeah. And then later on, we heard about one of the witnesses not being able to write his statement because he was unwell and all that. So we're all confused. We didn't know what was going to happen today, but I think the witness statement that was filed yesterday brings some clarity to what is going to happen today. So that's about it for now.
Again, so trying to put things in perspective, let's travel way back into time. So why are we here to start with once again? And I'm sure that people will never get bored with as many times as we try to get back to the bottom of this matter. It all started after the declaration of elections results on the 9th of December. Indeed, throughout the process, the voting process, the general reports were that the process itself was very smooth.
Yes,
but as soon as the declaration was done, and then there were amendments to the declaration, about 3 amendments, the final one happening on the 10th. Then the petitioner's supporters and himself at the time began to have issues, and there were protests nationwide against the ECs and the declaration of the EC's results and so on. And following that, we are here. And good. So we now see members of the legal team of the second respondent making their way to court right now. In 2013, the lead counsel for Nana Addo, who was then the petitioner, was Mr. Philip Addison. Of course, Mr. Philip Addison is not part of this team this year. So they are the members of the legal team. 2 of them, actually, there are 4 in number. The lawyer Yao Opong here, and then Mr. Frank Davis as well, making their way to the courtroom now. It means that all is about set for hearing to begin later this morning. I'm sure that should be in the next 15 minutes or so, because the court did indicate that it had adjourned till 10 a.m. on Friday, and that's just about 15 minutes away. And one of the things that you can't take away from the court is the punctuality with which it attends to issues. When the court says 9:30, it's on 9:31. And there's nothing like Ghana man time in court. So we're traveling back into time, and I just gave us a background as to what happened immediately after the declarations. But then on the 30th of December 2020, former President John Mahama filed the case in court. And since then, we've had the first day hearing began. It had to do with an application, and we've seen several applications from the petitioner's side. The first application was even before the court sat, which sought for some amendments in their original petition. You recall?
Yes, I do recall. Well, there were some small mistakes, error, if I should say, on the petition that was. On the petition that was filed by the petitioner, that is the former president, John Mahama. And so he applied for the court, or to the court, to be granted leave to correct his mistakes, actually. So the court sat and said, well, we are humans, we all make mistakes. And besides, the correction he was looking to do didn't affect the interior or the core of the suit, so there was no issue of court not allowing him or not. So they allowed. He went to correct his mistakes and came back to court.
All right, Barbara, we'll continue to break the issues down to our viewers, but we have more information and education concerning election petition 2020. We have people who are standing by in the studio and those who are joining them via Zoom through the studio to continue with the education. We'll be back here as and when there's fresh and breaking news from the Supreme Court. Otherwise, continue to stay with us here even as we continue educating you and informing you as well.
Back to the studios here. Thanks a lot to Abdul Hai Mumin, together with Barbara Kumahu, our correspondents there on the ground at the Supreme Court. And this is Ghana Television. This is GBC News. This is also Unique 95.7. And if you're listening to us anywhere outside the Greater Accra region, this is one of the networks or the radio stations of the Ghana Broadcasting Corporation. We are live on Facebook, Ghana Broadcasting Corporation, on the internet, GBC Ghana Online. My name is George Sapo, and we're continuing with our broadcast of the 2020 presidential petition that has been filed at the Supreme Court. We are just about less than 15 minutes away for the proceedings to start, and I'm sure by now you're aware that there's been a third witness that has filed his statement. That's Rojo Metonunu. His name was really prominent when the second witness for the petitioners took the witness box in there, and he's filed his response. What's going to happen next, we'll know when the court actually sits. But let's go quickly to the phone lines to talk to our usual guest who's been with us since we started this entire proceedings, Dr. Kwekwajiman Budu, who is a lawyer. He's a law lecturer and also the head of Law Center's Gimpa Faculty of Law. Doc, good morning to you, and thank you very much for joining us this morning.
Good morning, my brother, and thank you for having me once again. I hope you're doing well.
I'm doing well, thank you very much. I hope you're well too.
Yes, by God's grace, we can't complain.
All right. On Wednesday, when the courts adjourned to today, we're not giving reasons, but this morning, and I mean since last night, though, we had saw the statement filed by Rojo Metonunu, which is the third witness for the petitioners. What can we expect today, based on what has happened from last night into this morning?
All right, so, I mean, like you said, what is the only thing that we know, or the only information that we have, which is information that has been put out in the public domain, is the fact that there seems to be a third witness that has filed a witness statement on behalf of the petitioner, or to testify on behalf of the petitioner, which is Mr. Robert Joseph Metonunu. But as to exactly what is going to happen in court this morning, because at the last adjourned date, what took place was that there was an in-camera hearing which was requested by counsel for the petitioner because he suggested that there was a problem with a potential witness that they were thinking of calling, and they haven't been able to get that person's witness statement because of some health reasons. And for that reason, they wanted to have in-camera hearings. Whether or not that is Mr. Robert Joseph Metonunu, I think people are making or coming to that conclusion since that is the witness statement that has been released in the public domain. And so people are just naturally making that connection. I mean, I can't say that for a fact. I mean, you can deduce from everything that has happened that that probably is that witness. But I can't say that for a fact because I don't know for a fact if this is indeed the person they were referring to at the last adjourned date. As to what is going to happen today, I can't also tell definitely because at the last adjourned date, the court just adjourned to today at 10 a.m. It didn't tell us exactly what was going to happen, unlike in previous times where the court will say that this is what's going to happen at the next adjourned date. The last time they did not, or the next date of hearing. The last time they did not say so. And so once again, people are coming to the conclusion that by virtue of the fact that the witness statement of Mr. Robert Joseph Metonunu has come out at this time, it is possible that he will be called to the stand. I mean, I can't, sitting from where I am, I can't say that definitively. I mean, it probably is possible, or it's possible that that will happen, but I can't say on authority that that's exactly what's going to happen because we do not have that information, or at least I do not have that information. Maybe the counsel for the parties involved may have that information because they met the judges in camera. And so all we can do is wait for the court to sit at 10 and then we will know exactly what will take place.
All right. And usually in things like this, and since it's already been telecast on Ghana television and almost everyone is watching, and we did not know what happened on Wednesday, unlike what we get to know when the court is about to adjourn, the reasons and the directive the Chief Justice will give, who is the head of the panel. Usually when things like this happen, does the court really explain when they get back so that at least people understand what has happened so far, or they just move on?
I mean, if it's matters that are confidential, and if it's matters that were granted, they need to have an in-camera hearing in the first place. The most important parties we must remember in this case are the parties that are before the court, that is the petitioner, the first and second respondents. And they are the ones who are represented in court by their respective counsel. And so they are the ones that have the first-hand information. And so it doesn't really matter that the entire public watching on TV and other social media platforms do not know exactly what went on behind closed doors. As long as the parties involved have been apprised of the matter and know what is happening, that's most important. And so if the decision has been arrived at continuing with the next witness, or next witness is supposed to continue, that will happen without much hullabaloo. That's if everything that went on has been agreed to.
inna anonigiro. Okada, Okada,
The nation builder, Mahama, Brana Baya Wedmane. Mahama, 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 Oganamatu, Mahani, Sukuwadai, Hospitals, Aquapapa, Sagana Beya, Yebediye, Yahumbatoye, Ma, 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 1 million jobs, Mahama, Obabeyo, Obeye, Obeye, Oganamatu, Misia Lukoluko, Translate. Eyezu, Eyeza, NDC, Miawezo, Alada Nizongo, Kamami, Ingeleto, Ghana Bebia.
Ayukwele putu, Satupu, Mahani, Mahani, Mahina, Mahina, Anu Hudia.
Translate.
Atemuri, inna anonigiro. Ayuri, inna sabolaye.
Number two, economy, Galamse, youth employment, more jobs, Ghana Yende, Botomunya,
Uratu, uratu, Mahama uratu. Ejo, urta,
Oganamatu,
mojos,
number 2,
big push. Mahama, Mahama, ayukwele putu, Satupu, Mahani, Mahani, Mahina, Mahina, Anu Hudia, Ayukwele.
7th December, to Abanama Mahama, Miss Rao, Nipoto, Miss Rao, Mahama, Oganamatu, Mahani, Sukuwadai, Hospitals, Aquapapa, Sagana Beya, Yebediye, Yahumbatoye, Ma, 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 Toma Mahama, Oganamatu, Sikababa.
Lords, rate number J1/5/2021. John Dramani Mahama versus Electoral Commission of Ghana. Nana Adodankwa Akufo-Addo. John Dramani Mahama, please. The Johnson, I see you doing Ketia, my Lord, is representing the petitioner. My Lord, Jane Mesa, chairperson, is representing the first respondent. Mr. Peter McMahon is representing the second respondent.
Your Lordships, please appear for the petitioner, and with me, my learned friend, Tony Lither.
May it please my lords, Justin Amenuvo appears for the first respondent with me, A.A. Somwa Samoa.
If it pleases your lordships, Otuampa appears for the second respondent. My lords, with me are my learned colleagues Frank Davis, Kwekwe Srifi, and Yao Feng.
Lords, our next witness is Mr. Robert Joseph Mesolnuno, and he is appearing remotely, and I believe he can be connected.
I wish to raise a number of issues for consideration before we address the matter of the witness statement. My lords, my first concern is whether we have a judicial officer where the witness will be testifying from, so that we are certain that there's nobody or no means of prompting him when questions are asked. Because this is very important in our view.
We discussed in detail the modalities for this evidence and the concerns which were raised by counsel on the other side. And we all took it into consideration. So, Mr. Nakutampa, let's move on and do some business.
Since that discussion, in fact, that very day, they wrote waiving those confidential matters.
Yes.
And therefore, we are saying that this is a trial. Normally, even when somebody is giving evidence from abroad, you have an officer present whilst he's giving evidence. I think this is a very fundamental issue I'm raising.
Mr. Kotampa, why didn't you come with the other counsel into chambers to tell us this morning?
My lords, because we were told that this matter will be discussed, the case is now to be in public. That is why. Otherwise, I would have done that. But I submit that this is a very major concern for the second respondent. We want to be sure that the witness is not being prompted or given any assistance. And that can only be properly done if there is some oversight by an official of the court.
What's your next concern? You said you have a number.
Yes, my lord. My next concern is your lordships will notice from the witness statement and the attached statement of truth that the attached statement of truth reads, I, Robert Joseph Metomunu, say that I am the witness herein, and that I made this statement in respect of this presidential election petition, and that to the best of my knowledge and honest belief, paragraphs 1 to 16 of the witness statement are true to the best of my knowledge, information, and belief. Now, that means that the witness has only sworn to paragraphs 1 to 16 of the witness statement.
Mr. Kutampa, what are the legal arguments around this?
No, my lord, I'm coming to the point.
No, Mr. Kutampa, I thought you said you had some preliminary matters.
Yes.
No, wait. Now, I think this you raise when an attempt is made to put the statement into the proceedings. So we'll take the preliminary ones. This relates to the statement itself.
Very well. Available to your lordship's guidance.
With the first preliminary issue that you raised, I think we can observe his demeanor. I mean, you can observe his demeanor if somebody is talking to him or passing the document to him. We can observe from the screen. So I don't think.
My Lord, can I be of assistance to the court? My Lord, may I be of assistance to the court? My Lord, we are completely in agreement with the principle that a judicial officer can be in attendance. We have absolutely no problem about that. And my Lord,
Peter, can you speak into the microphone?
I'm sorry.
Otherwise, we lose the record.
In terms of that principle, it's very clear. We are not in objection. So it should take perhaps not more than 25 minutes to have a judicial officer present at the location where he is to allay the fears. So respectfully, my lords, if a judicial officer can be designated, that judicial officer can go to the venue, which, you know, that should not be a problem.
Would it be safe? How proximate can this judicial officer get? What you have told us.
My lord, in fact, I'm certain there's actually a medical officer also in attendance at the location. So I'm sure that he can have a discussion with our medical officer in terms of the issues that your lordship is addressing. I'm pretty certain about that. The medical officer has provided a letter also to the court, and I believe that he can address that issue. Currently, according to the review from the day that your lordships granted us indulgence, that issue really does not arise currently. But the judicial officer probably can actually be in the room, because I think, as far as I recall about the judicial officer can just go there, and in conjunction with both the medical officer and
please, we will adjourn for 30 minutes and consider this. No, you will send somebody. Yes. Okay. Yes, we will arrange with you through the registrar. Yeah, okay.
All rise.
The victory of the
That will take place through some other means. I mean, I don't think we were told exactly the means through which that will be done. I stand to be corrected though, but
again from deductions, it might be virtual means.
Yes, I mean, we can assume or make that conclusion. That assumption is a reasonable assumption to make. So this will be one of those instances where it's not possible to take the evidence or get the evidence directly or the testimony of the witness directly in court. You realize that counsel for, I believe, was the second respondent, even alluded to situations whereby a witness may be out of jurisdiction and yet testimony can still be gotten, or you can get testimony from a witness in that regard. Of course, there has to be some safeguards in place to ensure that the testimony is under oath, for instance, and there isn't any untoward things going on. So those are some of the circumstances under which it will be necessary, or it won't be necessary, or the court may still take the testimony of a witness who is not necessarily available in court or within the jurisdiction of the court.
And we realize that the counsel for the second respondent asked that we have a judicial officer present at where this witness is. What significant change or effect will that judicial officer who's going to be present there bring to this whole, let me say, hearing the witness?
I mean, it's a safeguard. So, for instance, if a witness comes to court, the person is sworn, swears an oath, or affirms, or whatever other process is available. And that is to ensure that the person knows that he or she is under oath and that the testimony is truthful to the best of knowledge of that particular witness. And so to have a judicial officer, or to request that a judicial officer be present where the witness is to ensure that, for instance, you see that when the first two witnesses of the petitioner were in the box and they were being cross-examined, they didn't have or get assistance from their counsel. And so, but in this situation, this will be a situation whereby the witness is not available to testify in court, and the court seems to have agreed to that, for the witness to testify from some other place. And to ensure that there isn't, or that seems to be the argument that the second respondent's counsel was making, that to ensure that there isn't any coaching or anyone guiding the witness in terms of how to answer the questions and the specific answers he should give to the questions that are posed, they want a judicial officer to be there. And once the judicial officer is there, appointed by the court to go to the location of the witness, I mean, you can be rest assured, or at least in the minds of the second respondent and all the parties for that matter. And you saw that the petitioner's counsel did not object or have any problem with that, so that everybody is clear in their minds that it is a fair process that is ongoing, because you have an official from the court who is there to ensure that nothing untoward is going on. Because if the witness was given his testimony in court, witness wouldn't have the opportunity to refer to anybody or have anyone whisper anything into their ears or show them any cards or any answers or anything of that sort. So this is just to ensure that the witness is testifying as though that witness was in court. And the presence of the judicial officer will ensure that safeguard and let people rest easy and not be suspicious of the circumstances surrounding the testimony generally.
All right. Doc, generally, is there any advantage or disadvantage when a witness is testifying outside court or outside a jurisdiction?
I mean, ideally, you would want the witnesses or involved in a case to be testifying in court, because as the Chief Justice, I believe, even pointed out, or one of the justices pointed out, initially when counsel for the second respondent raised concerns about the out-of-court testimony, you remember that the justice suggested that they could see the demeanor, they will be able to still tell whether that person is being coached or not through the demeanor of that witness and all that. So generally speaking, if the witness is in court, as part of determining whether that witness is a credible witness or is telling the truth and things of that sort, you are able to observe that witness's demeanor, how he behaves, how he answers the questions, his facial expression, his movements. All these things are taken into consideration when the judges even come to their conclusions as to whether or not he was a credible witness or whether or not the testimony itself was worthy or was proper or was the truth that he was testifying about. So it is ideal that the witness is in court, because there you have a first-hand opportunity to observe all these things that I've just laid out.
Okay, I think we've lost Dr. Kwekwajiman Bundude on the line. We'll work on his line and quickly get in touch with him. If you're just joining us, it's a broadcast of the 2020 presidential election petition, which is being heard at the Supreme Court. The court sat, the last time they sat was on Wednesday, and it was adjourned to today. And before today, yesterday, we got to know that the second petitioner has filed a third witness statement. Okay, I'm told that we have our guests back on the line. Doc, we lost you there, so you can continue what you're saying.
Sorry, I was saying that you have the opportunity when the witness is in open court, to observe the witness's demeanor, his facial expressions, his movements, how he reacts to questions, how he answers the questions, and all these things as well. So ideally, it will be ideal that you have the witness in court, so that you have first-hand opportunity to observe some of these things, which goes to the credibility sometimes of the witness in question. But if it's that the witness is not testifying in court and the witness is outside the jurisdiction and things of that sort, it's difficult to have that first-hand opportunity to observe some of these things, even though there are no safeguards. So, for instance, in this situation, we believe that a judicial officer will be sent there so that he ensures that there isn't anything improper going on and all that. But still, that is not like the witness is in actual court. It's quite different. That's why it's advisable, or it's sometimes preferable, let me put it that way, that the witness is in court. But obviously, there may be cogent reasons why that witness may not be available, and the testimony of the witness nonetheless will be required, or it will be needed in the particular matter that's before the court.
But with things like this, is it usually a normal practice in the legal practice?
And it happens. There are times where a witness is outside the jurisdiction and the testimony of that witness it's needed in that particular case. Sometimes testimony can even be preserved for use by the court subsequently and things of that sort. So it can happen. It is part and parcel of the court processes in relation to witnesses and testimony and things of that sort. So it's not particularly strange, as we've seen demonstrated before the Supreme Court, that there seems to be some particular reason, health reasons, which we shouldn't go into because that
someone's private issue. Yeah.
Private and all that, yes. But there seems to be some problem why that witness is not available in court. But clearly the petitioner feels that that witness's testimony is important to their case. And so that's why they probably sought the leave of the court for the court to give them the opportunity to file that third witness statement so that they can have the testimony of the witness in evidence. It will be considered as part of the evidence that's adduced. That is, if it is some of the things that he's saying is not objected to in the witness statement and things of that sort. And of course, subject to what happens during cross-examination and re-examination and all. On the totality of all the evidence, the court will have a clearer picture in relation to this testimony that a witness is given vis-a-vis the case that the petitioner has brought before the court.
All right, and it's obvious that we're going to use technology for what's about to happen, and for instances like that. On the day that technology decides not to be friendly, does it and can it affect the smooth run of a case or any trial that's going on?
Oh, I mean, we know how sometimes we have unreliable internet connection in some parts of our country and all that. But we also know that it can be reliable as well. And I mean, of course, technology can disrupt proceedings one way or the other. But I mean, there's still, it doesn't mean that it would let the whole proceedings, negate the proceedings, or let the proceedings come to an end or anything of that sort. It's possible that during court hearings where there's a need for evidence to be taken via video link, because if you look at the High Court Civil Procedure Amendment Rules of 2014 CI 87, it introduces the fact that evidence can be taken by video link. So the court may allow a witness, for instance, to give evidence through a video link or by any other means. And so, clear in the rules of the High Court, for instance, that video link is allowed in terms of, so you can think of Zoom, Microsoft Teams, and Cisco WebEx and all that. There are several means by which you can have this video link or the witness testify via video link. Whether or not the internet facilities and the connectivity will hold up, that is something that we cannot tell. It depends on the particular connection that you have and all that. That's something that we know can be unstable at times, but can also be stable, but doesn't necessarily mean that it would negate proceedings. Or, of course, it can affect proceedings, but there definitely will be a continuation, and there definitely will be a time that it will hold up, and so things can go the way they are meant to go.
All right. Still on this same note, we know that when a witness moves into the witness box, he's made to swear an oath and all that. So in an instance like this, will the how is that going to happen if the person is supposed to swear the oath?
Oh, the oath will be administered to or by a judicial officer, and I believe that's part and parcel of why a judicial officer will be sent there to administer the oath on behalf of the court. And I mean, it can even be done virtually, because if the person is testifying online, it's as though the person is present in court, and so the oath can be administered that way. I don't think it affects the validity of the oath or the testimony that that person is being given. But if you have a judicial officer who is there, that person can do so too. And like I said, that person can be the safeguard to ensure that there isn't any foreign element introduced in terms of the testimony that the witness is given, that somebody is not there sitting in front of the witness coaching the witness in terms of the answers that he has to give and all that.
I remember some time ago I asked a question whether usually when you have a witness and you're a lawyer, whether usually you coach the witness as to how to answer questions and all that. In court and in answering questions, what if the witness is coached or not? What's the effect? What's the effect on the case?
The point we need to understand, and we need to let our viewers and listeners understand, is that the testimony that a witness is given must be testimony that is in his own personal knowledge, that he has personal knowledge of.
Yes, and which is in the witness statement.
Yes, and so nobody else aside that witness is privy to, or maybe there may be people who know some of the things involved, but the witness in his testimony must speak to matters that is within his personal knowledge.
Yes.
And so when answering questions in the witness box, for example, during cross-examination or even in examination in chief, you have to answer questions honestly and truthfully, things that you know about, generally speaking. So nobody else can or should be involved in that process because they are matters that are within your personal knowledge. And so that's why, like I said, there is what we refer to as hearsay evidence or the rule against hearsay evidence, which prevents hearsay evidence. And hearsay evidence is simply evidence that is not first-hand, that you, the witness, do not necessarily have, but it is removed. So we refer to as maybe rumor or gossip or second-hand information. It is not second-hand information that is required of witnesses when they are testifying. It is first-hand information, information that is within their personal knowledge that is required. That's why nobody else should be involved in that particular process. Of course, there are exceptions to this hearsay rule, which at another opportunity we can delve into for the education of the public generally.
All right, just hold on for us. We'll go for a quick break. When we return, I have a follow-up to this particular question. We'll be right back. We're going for a quick break. Stay with us. We'll be right back.
Galam se pota banyo Sankofa yenchi Don Mahama nepe Yanu yengo Sankofa yenchi Don Mahama nepe Dafi Mahamo Don Mahama nepe Dafi Mahamo Don Mahama nepe Yanu yengo Don Mahama nepe Yanu yengo Don Mahama nepe Sankofa yenchi Don Mahama nepe Sankofa yenchi Don Mahama nepe Yanu yengo Sankofa yenchi Don Mahama nepe Sankofa yenchi Don Mahama nepe Sankofa yenchi Don Mahama nepe Omanuma yedio Omanuma mahamo Asisa wajinyo Ama odinada Don Mahama nepe Yanu yamu Don Mahama nepe Gana waribe Mahama nepe Sankofa yenchi Gana for Don Mahama nepe Sankofa yenchi Gana for Don Mahama nepe Omanuma yedio Omanuma mahamo Asisa wajinyo Ama odinada Don Mahama nepe Yanu yamu Don Mahama nepe Gana for ribe Sankofa yenchi Gana for Don Mahama nepe Sankofa Sanko Don Mahama Nepe Abu Kwame Ewo Sanko Faichi Don Mahama Nepe Yama Kwame Ewo Sanko Faichi Don Mahama Nepe Nobody Kwame Ewo Sanko Faichi Don Mahama Nepe Awasi Kwame Ewo Sanko Faichi Don Mahama Nepe Ghana for Mutina Waboy Mahama Mutina Waboy Kekos for Mutina Waboy Mahama Mutina Waboy Sankofa Ichi Don Mahama Nepe Sankofa Ichi Don Mahama Nepe Yafi Mahamo Don Mahama Nepe Yenu Yahuo Don Mahama Nepe Sankofa Ichi Don Mahama Nepe Yenu Yahuo Don Mahama Nepe Yafi Mahamo Don Mahama Nepe Sankofa Ichi Don Mahama Nepe Yafi Mahamo Don Mahama Nepe Yenu Yahuo Don Mahama Nepe Yenu Yankianya Don Mahama Nepe Don Mahama Nepe Somebody Yahuo Don Mahama Nepe Yenu Yahuo Don Mahama
to do it himself. Yes, they are ready. So.
Can you hear us?
Yeah, I can hear you.
Thank you.
So I believe the register will correct.
So, my lords, we ask your permission to swear the witness. So, this is the Bible. Lift it up and say after me. Say, I, mention your name, please.
Robert Joseph Ethel Nunu.
Do swear on this Bible.
Do swear on this Bible
that the evidence I will give this case.
That's the evidence I will give in this case.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
So help me God.
So help me God.
That was SOB in English.
Can you give your full name to the court? Can you give your full name to the court?
Have you unmuted? Have you unmuted?
Can you hear me?
Yes, now we can. Yes. Please give your full name to the court.
My name is Robert Joseph Betel Nun.
Now, you have put in a witness statement in respect of this case. Is that right?
My Lord, that is correct.
My lords, may we have the witness statement adopted in these proceedings. And do you have a copy of that witness statement with you?
Yes, my Lord, I have a copy of the witness statement.
Very well.
My lords, we wish to draw the court's attention to the fact that the
Yes, my lord.
Yes, do you have any objection or comments or whatever?
No, for now,
Okay.
I will abide by my learned colleagues' submissions.
Yes, my lord. The witness statement has a statement of truth attached to it. And my lords will see. And I read, I, Robert Joseph Metzonunu, say that I am the witness herein, and that I made this statement in respect of this presidential election petition, and that to the best of my knowledge and honest belief, paragraphs 1 to 16 of the witness statement are true to the best of my knowledge, information, and belief. My lords, that on the face of this document means that the witness is swearing to only 16 paragraphs of the witness statement. We would submit that paragraph 17 to 32 should be struck out as not part of his witness statement. My lord, this is a very important issue, because in our view, this witness statement and the truth, the statement of truth, show that the witness statement was first crafted up to 16. And it is only after the cross-examination of Professor White and the rest that these other 16 paragraphs have been added there.
When did Dr. Professor White leave the witness box?
He left the witness box on
Wednesday.
Wednesday, yes.
Mr. Kutamba.
No, my lords, may I be permitted? No, it isn't.
Speculative.
My lords, if I may be permitted to demonstrate my point. My lords will notice that a letter was written to your lordships that I'm sure we can all take judicial notice of by counsel or solicitor for the petitioner. And if your lordships were to look at that letter, Your Lordship will notice that the letter was written on the 4th of February. But attached to the letter are 2 other letters, both dated 3rd of February, the very day that they sought the leave, and gave the impression that the witness was so sick that we needed to have...
Mr. Kotombo, how are we supposed to work with the submissions you're making? How do you corroborate them?
Excuse me?
How do you intend to corroborate the matters you're bringing up? How do we work with these submissions?
My lady, it is a fact that it was on the 13th, it was on the 3rd, that they raised these concerns about...
So your submission is that paragraph 17 upwards should be struck out. Is that your submission?
Yes, and I'm trying to explain that this is not just a typo error. It is indicative.
What you are saying is very speculative.
No.
You made a point that the statement of truth admits only up to paragraph 16. But it is clear from the document that he has signed after paragraph 32. So whether the paragraph 17 to 32 was added after Dr. Pasewai's evidence or not, it's neither here nor there. The point is that the statement of truth says that he verifies paragraph 1 to 16.
Yes.
That is the point.
Yes.
Yeah. So I think that should be it.
Very well.
My lords, unfortunately, I do have to make reference to certain comments that my learned friend made, because not only are they speculative, but with respect, they cast aspersions onto my integrity. I did indicate that there was a medical review on that day. I did give that indication, even whilst we were in court. And I indicated that I would be in contact with both the medical official as well as the witness. I believe those were clear indications, and I did that in the morning before your lordship. So for it to be suggested that somehow some things have been done, you know, I think is really not just unfortunate, but I really do not expect that we should get to this kind of death. My lords, we took the liberty of notifying them as soon as we came to court that day that this is a situation, and we gave the facts. So, my lords, I do not think that my learned friend should be entitled to make these aspersions.
We've stopped him. Yes, because we thought that when counsel on both sides maybe give concessions, the court should take it as coming from honorable men at the bar. So please, let's go on. Let's go on.
So, my lords, we were at the point of having the document adopted. He's raising an objection. Very well. Very well. Very well. So, my lords, may I respond to that objection? My lords, respectfully, that objection is without a basis. Because the witness has put his signature under the 32 paragraphs. And my lords, the witness that is actually the only place on the document where the witness has signed. Now, my lords, the witness can himself explain and I do not wish to anticipate, but the witness can, I'm sure, explain whatever is needed to be explained in relation to this document. I do not want to provide any. I'm not going to say that.
My lords, I'm happy that counsel is saying that the witness himself can explain, which is to say he doesn't have a response to my objection. And it is not for the witness to explain at this time. The witness, but that's...
Mr. Kusampo,
yes,
if you look at CI 87, the rules are very broad. From 3E to 3F, the rules are very broad. He does not need to be confined to his witness, even to the witness statement. So I think that you should look at the rules.
My lady, I didn't get that. You said
CI 87.
One doesn't need to be confined to the witness statement. Is that what you are
Hey, kindly look at CI 87 from 3E down. The role of the witness statement. Yes.
Yes. Yes. My lord, but our point here is that there's no good reason. There's absolutely no good reason. You can't swear to a 2-paragraph witness statement and say that you are swearing to the truth of the first 16. It shows that there's a real problem, because it's not as if he said he was swearing
So
to...
you want a ruling?
Yes, my lord.
I think the way forward, can we suggest that you apply to amend the statement of truth?
My lord, respectfully, I would have done that. I did not want to preempt, because the witness actually has drawn my attention to certain matters, not only in relation to that part, but in relation to a couple of other, where instead of 2020, it's 2021 and so on. He's drawn my attention to it, but I did not want to be the one to say that. I think, respectfully,
In evidence.
Yes, my lord, the document is in evidence, but my lord will see that the statement of truth is not a statement that he has signed to, but it is after his signature.
Yes.
And that is why I thought that, given the opportunity, the witness himself can, because as I said, my lord, I can say from the bar respectfully that he actually drew my own attention to it. I myself had not, he drew my attention to the fact that...
But as counsel, can't you get...
Very well, my lord.
Amend it so that we can make progress.
My lords, may I respectfully apply to have the paragraphs 1 to 16 indicated under the witness's signature to read paragraphs 1 to 32. The statement of truth is in respect of the whole of the witness statement. And the whole of the witness statement has 32 paragraphs. There's absolutely no basis for insinuations about...
The basis, Mr. Chikata, that is the document you brought to us.
Okay,
there is a basis. You know there is a basis. This is what you brought to us. So he could have let it go, but he didn't let it go. But...
and let's move on.
My lords, I very well.
By court, leave is granted for the amendment sought. Let the statement of truth cover paragraphs 1 to 32 inclusive. That's all.
We're most grateful, my lord.
Yes, my lords, we will pray to have certain paragraphs in the witness statement struck out. On the grounds that they are not supported by the pleadings. Also, on the further ground, my lords, we are referring to part of paragraph 4, starting prior to the so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duties she was supposed to perform in order to be able to declare a winner of the election, as she attempted to do. In the entire period after the election on 7th December, she made a couple of very brief visits to the strong room.
From line 3.
Yes, my lady.
Prior to.
Prior to the end. Yes. My lords, now, paragraph 5.
No. And your reason for
Is that it is not borne out of the pleadings, my lord. My lord, paragraph 5. We pray to be struck out as not based on the pleadings. My lord's paragraph 6. We pray should be struck out. Again, it's not borne out from the pleadings. And these are material allegations of fact that if they intended to rely on, they should have pleaded. My lords, paragraph 7 is equally not borne out of the pleadings. My lords, these are very serious material allegations of fact. And if they wish to rely upon it, they should have pleaded same. These are basic rules. To borrow my learned counsel on the other side, they are elementary rules of pleading. My lords, again, my lords, paragraph 8. It's not based on the pleadings. And we pray that it be struck out as such. My lords, your lordship have ruled on the question of authenticity in respect of the attempt to seek originals. And our objection on that issue was that they had never in their pleadings raised issues of authenticity, which are very serious matters. But following the court's ruling, they are seeking to introduce authenticity issues through the back door. They should not be permitted to do so. Paragraph 9, my lords. My lords, may I proceed?
Can we be clear if the objection is to a part or because he's generally given us a portion of the paragraph? So just to be clear whether it's the whole or...
That paragraph can only be understood as a whole. So as a whole should go. Nothing should be left out. My lords, we again object to paragraph 10 as a material statement of fact, not found anywhere in their pleading. It is an attempt, like the earlier ones, to build a new case after the event, after the cross-examination of the first and second witness. My lords, this convenient excuse of the witness being misled is nowhere in the pleading.
To paragraph 11?
Yes.
Or what?
That's not 11 I'm speaking about. Paragraph 11, where the witness claims, I admit I was misled.
So are you objecting to paragraph 11?
That is so,
Okay, you had not stated so. You had not stated so.
I'm sorry. We are objecting to paragraph 11 on the grounds that it is not grounded on the pleadings. My My Lords, it is our view that paragraph 12 should be struck out as an opinion. We don't plead opinions, we plead facts. Sorry. My Lords, this is evidence. And the evidence here
Mr. Kutampa.
Yes, ma'am.
You mentioned that you are objecting to 7 paragraphs out of the 32.
Never, my Lords. I think
you mentioned 7.
I mentioned no number.
I'm sorry.
No, my Lord.
Okay.
I said certain. Very well, my Lords. My Lord, paragraph 15. The portion that reads, both could not be authentic. Only by getting the originals of these documents can there be clarity on exactly which is the genuine form from the region. My Lords, this is again an attempt to slip through the back door. The question of production of original documents. An attempt to which the court firmly closed its door.
Yes.
My lady, my Lords, paragraph 16. Is not to be found in their pleadings. Lords, refer to paragraph 17. Lords, it is our view that it is not pleaded. It should be struck out.
Mr. Ngutuampa,
yes.
Are you saying it is not based on the pleading or the petition?
It is not.
Or you are not? Or you are saying it is not in it? It is not based on it.
It's not based on it. My Lords, paragraph 18 raises once more the rather infamous question of authenticity and the need to produce the originals. lords, this whole issue of consultation, paragraph 22.
You are seeking to attack paragraph 30.
Yes, paragraph 18. My lord, no. Part of. Yes. My lords, I believe I've dealt with paragraph 18.
Yes, you have been recorded. Yes, you've been recorded. You are saying that he seeks to introduce the originals. The issue of authenticity. Yes, through the back door.
Yes. My lords, paragraph 19. This is a story about making an error when he signed. And Lord, it's not based on the pleadings.
So if a man wants to say I made a mistake, he shouldn't be allowed to say it.
My Lord, this is a very, very material fact. My Lord, it's a very material fact because he had already signed the document. So if he was...
You see, it's not going to be under oath to be examined.
My Lord, I'm saying that before we...
No, I'm asking you a question.
Yes, but before he's cross-examined, we must make sure that the evidence that is given is supported by the pleadings, insofar as it relates to material facts. Insofar as it relates to material facts. And it is our submission that this allegation is an extremely material matter, and they ought to have pleaded it. My lords, it applies equally to paragraph 20. My lords. My lords, we pray that paragraph 22 Yes. Oh, I see. My lords, paragraph 22 is directly connected with 21. It's only a further elaboration of
Objection to
paragraph 20. 20, yes.
20.
Yes.
The basis for the objection. I'm recording you.
My lords, my lords, it's our case that, again, this is a very material allegation of fact, and it should have been pleaded because they are seeking to build their case on it. Should have been pleaded. Nowhere in the petitioner's initial petition nor its amended petition do we find any reference to this material, factual allegation. Lords, we refer to paragraph 22 and say that this is not based on their pleadings. Indeed, their pleadings refer to the letter that they wrote to the EC chair. And according to them, the EC chair ignored them or did not respond to their concerns. There's nothing in the pleading about this very important allegation of fact. If they were ready to attach the letter they had written to the EC chair as part of their petition, it beggars belief that these very serious allegations of fact against the EC chair was not pleaded.
This is in relation to paragraph
22, my lord. It says that he sought to consult with the chairperson of the EC. I also needed to receive feedbacks on the concerns I conveyed to her the previous day.
Seem to be relating it to a letter.
Yes.
But there's no relationship.
No,
to any letter.
There's no relationship, my lord. But my point is, if they found it important a fact to plead about the letter, this serious allegation of fact should have been part of their. It's not pleaded.
There's no foundation in the pleadings, or it is
It has no basis.
Because there's a sharp distinction between
my lords,
evidence and material facts.
I'm very well aware of that.
Yes.
So I'm sorry. I'm sorry that I said it's not based on the pleadings. My lords, the paragraph 23 is equally not based on petitioners. Yes, my lord, pleading. My lords, we object to paragraph 24 for the same reason. 24, my lords, that it is not based on the pleadings. These allegations of deceit, they should have made the allegation and even given particulars of same in their pleadings, in accordance with the rules CI 47.
The entire paragraph or a part of it?
No. My Lord, we would pray that the entire paragraph be struck out.
And where does the paragraph talk about deceit?
My Lord, it reads, there was nothing in the discussions which could have given me any reason for doubting the word of the chairperson of the EC.
But it doesn't say she deceived him.
But my Lord, if you go into the next paragraph, it shows that the allegation is that the chairperson send them on this.
Your submission was that it's an allegation of deceit and particulars of it should have been given in pleadings. And I'm saying that I don't see any reference to deceit. He said, I had no reason to doubt her word. Is that an expression that she's deceived him?
My Lord, see, yet if your Lordship, with respect, will refer to paragraph 29. No, but my Lord, they are connected.
Unless,
my Lord,
oh, please, counsel, is it not a practice that if a judge is speaking, counsel should keep quiet?
Well, no,
unless you want us to read it in conjunction with the other paragraph.
Precisely.
Yes. You are not doing that.
Now, my Lord, it is our submission that some of the paragraphs cannot be understood standing alone by themselves.
Yes, you are on your feet. Yes, you are on your feet.
No, my Lord, that's precisely what I was doing.
Dr. Tampo, are you suggesting that we should read paragraph 24 together with paragraph 29?
Yes, my Lord, together with paragraphs 29 and 30 and 31. It's very clear.
I think that 24 stands on its own, so anyway, go on.
Yeah. My Lord, if you read these paragraphs together, the allegation is very clear that the EC chair deliberately led them on a wild goose chase in order to declare the results in their absence. That is the gravamen of those paragraphs. And my Lord, I'm saying that these are very material allegations. And they ought to have been pleaded and the particulars of which given.
Under paragraphs 24 and 29.
That's an allegation of a state of mind, an act by the chairperson with an intent. And he ought to have given the particulars of that intent to mislead in their pleadings. My Lords, if your Lordships do agree with us, then it is our submission that paragraphs 25, 26, would become irrelevant and would have to be struck out as such. My Lord, we've already spoken about 30 and 28.
28?
No, 29, my lords. Yeah, 20 and 29. 29 and 30, yeah. My lords, 31, in our view, follows accordingly. It's the same narrative of having been misled and how he couldn't believe that the chairperson could do that. My lords, that is all. Yes.
You make what he can't believe is also part of your objections?
Excuse me?
What he cannot believe is also part of your objections. 31.
Yes, I'm saying that 31 is part of that set of paragraphs that are speaking to the question of deceit and being misled. A deliberate attempt to mislead them. That's... Yes. 31, my lords, reads, I can still not believe she did what she did in the light of my experience. So it's talking about what she did. That is misleading her. That's the fundamental, that is the sentence. The other things are what we call adjectival clauses in English language structure. The main sentence is, I can still not believe she did what she did. That is the sentence. And then in the light is just qualifying.
Inviting us to strike out paragraph 31.
Because, my lords, it is not based on the pleadings and partakes of the same problem that 24, 29, and 30 have. So, my lords, we accordingly pray that all these paragraphs be struck out.
Mr. Agudampa, in view of, can you correct me, agree with me if I'm right. So, apart from paragraphs 1, 2, 3, and 32, you are asking us to strike out the entire witness statement. Am I right? That those are the only paragraphs that you are not objecting to?
My lords.
No, I just want, because it's an easier way of understanding it than, yeah. Am I right?
My lord, I just want to be sure that my lord, part of 15, not the whole of 15, we've indicated which part. Also part of 17 should be struck out.
So 15, which part?
15, he says the portion.
Both could not. Right to the end of 15.
Okay.
Paragraph 17, my lords. From that, the portion beginning, that was one of the things to the end. I've read that already. I just do that. Which paragraph? Huh? Which paragraph? Refer to paragraph 4, that the portion you want starts from prior to. I think I've done that.
Yes, yes, you did.
Wake up.
Paragraph 3 of 4. Paragraph 4, line 3 today.
Very well.
Paragraph 4, line 3 today.
I'm most grateful, Lord. And paragraphs 'I don't believe we objected to 14. Paragraph 14. We are not.
No, you didn't. You didn't.
Actually, paragraphs 12, 13, and 14.
Okay.
It did not attract your attack.
No, 12 is included. It says, paragraph 12, opinion, not based on facts.
My lords,
Have to hurry up.
yes, we didn't take objection to paragraph 14. We didn't. We took objection to part of paragraph 15, beginning both could not be authentic. And we objected to paragraph 16. For paragraph 17, we objected to the portion that reads, that was one. Yes. And 19. Yes. Yes, my Lord. So that is our prayer, my lords.
Yes, my lords, in support of the submissions of my learned friend, I wish to draw the court's attention to the case of Aboaba versus Additional, 1946, 12 Waka 18 at pages 19 to 20.
It has been settled in so many legal cases.
That is so, my lord. My lords, this is what readily came to mind. With your kind permission, this is what readily came to mind on my screen. My lords, the object of pleadings is to compel the parties to define the issues upon which the case is to be contested and to prevent one party taking the other by surprise by leading evidence or material facts of which the other had no due warning. The penalty for failing to plead a material fact is the exclusion upon objection being taken of evidence to establish it, where evidence which could have been ruled out as inadmissible because it is adduced to prove a material fact which was not pleaded has nevertheless been adduced without objection and is before the judge,
goes on and says the trial judge was bound to take into consideration and the appellant ought not having raised his objection. So, my lords, it is our submission that at this key moment, the objection is timeously raised and it should be considered. My lord, the local authority that also comes to mind is Akufo-Addo versus Catalan. Yes, my lord. Yes, my lord. With respect.
That is our practice, please.
Yes, my lord, I concede. I do concede. I'm sorry, my lord.
Order in court, please.
My lords, I submit that there is no basis for striking out any of the paragraphs in the witness statement, and I will unfortunately have to go one by one, and sometimes the same point will apply, but because we're dealing with specific...
But if some of them can be lumped together and treated together, we would appreciate it, if at all possible.
Very well, I'll do my best. I'll do my best to do that. Unfortunately, each of the parts, but very well. I will do my best to avoid having to go into each of them. But my lord, if we start from the paragraph 4, which is being objected to from the second sentence, prior to her so-called declaration on 9th December 2020, the chairperson of the Electoral Commission did not perform the duty she was supposed to perform in order to be able to declare a winner of the election as she attempted to do. In the entire period after the election on 7th December 2020, she made a couple of very brief visits to...
So, Mr. Shikata, the failure to perform duty you are complaining about, is it the shortness of her visits? Is it the paucity of visits? Is that what you mean?
No, my lords, it is not the paucity of the visits. It is the content of the visits. And the witness statement addresses the content very clearly. The witness statement is very clear about that. And the witness statement it is not the paucity of the visits. I mean, the witness statement is very clear in the fact that, and if I may,
the petition. Are you referring to the petition?
No, I'm going to refer to
the witness statement.
The witness statement itself.
Their objection is that it's not borne out by the pleadings. It's not borne out from the pleadings.
Yes, but I was coming to that, but I thought you threw in a question about whether it's the brevity of the visits. And I was suggesting in response that the witness statement makes it quite clear that it is not the brevity of the visits. Because in paragraph 27, for instance, paragraph 27 is indicated, in any event, by the time we left the EC premises, the strong room verification process with the chairperson of the EC had not even begun, much less come to an end. All that had happened in the strong room was a series of informal interactions and not the process with the returning officer that is set out in the Constitutional Instrument 127. So that's just a direct response to the question that it is not the brevity of the visit that is the concern of the witness statement.
But Mr. Articular, you see, yes. I have read the petition again and again, and there's nowhere in the petition where this whole story about the strong room had been pleaded.
My Lord, can I? My Lord, part of the problem is I was going to go paragraph by paragraph as he did.
Yes.
And then I had a question related to whether the brevity of the visits. And then, so I was going to go paragraph by paragraph in terms of the pleadings. In terms of the paragraph of the pleadings. I was going to do that.
Okay.
My Lord will see that from paragraph 6 of the amended petition of the petitioner. It is indicated as follows: purporting to declare the results, Mrs. Gina Dukwe-Mensah, chairperson of first respondent, and the returning officer for the presidential election said, at the end of the transparent, fair, orderly, timely, and peaceful elections, the total. So here's a reference to her own statement about transparency, fairness, orderliness, and so on and so forth. Now, my Lord, the petitioner then goes on, after referring to the percentages and so on, the petitioner goes on, and my Lord, those references, I just don't want to have to go through all the details.
Please go through them because I'm really confused.
Very well. Very well. So, after 6,
Mr. Chikata, my mind is on the testimony that she failed to perform her duty in that paragraph 4 that you are referring to. My mind is on that testimony. So you refer to paragraph 6.
Yes. I refer to paragraph 6. And in paragraph 6, my reference is to what was stated about how she made the declaration. And in paragraph 19 is a very direct statement that the first respondent and its chairperson, Mrs. Gina Dukwe-Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Then, 20, in declaring second respondent as the winner of the 2020 presidential elections on 9 December 2020, the chairperson of first respondent, Mrs. Gina Dukwe-Mensah, acted in flagrant violation of the 1992 Constitution. 21, first respondent and its chairperson, Mrs. Gina Dukwe-Mensah, in the conduct of their duties, are required by Articles 23 and 296 of the 1992 Constitution to act fairly, reasonably, candidly, and not arbitrarily or capriciously, and to comply with the requirements of law. Now, my lords, if the witness is therefore providing testimony that shows why there has not been compliance with legal requirements, if the witness is providing testimony in respect of that. That cannot be said not to be based on the pleadings. More so, where the answer of the first respondent itself puts those matters in issue. First respondent in paragraph 4 of her answer says, first respondent says further that the 7th December 2020 presidential election was regulated by the 4th Republican Constitution 1992 and the Public Election Regulations 2020 CIT. So first respondent is taking issue with the pleading, the allegation that you did not act in accordance with the Constitution and in accordance with your legal obligations. It's taking issue and says not only that they are regulated by these, the Constitution and CI 127, but goes on actually to set out in detail, which I will not get into, but sets out in detail how how the first respondent claims there was compliance. That is the whole essence of what is in paragraph 5. The whole essence of those 4 stages that she describes, particularly paragraph 5, Roman 15, and Roman 16. Paragraph 5, Roman 15, and Roman of her answer. She said, the Form 12s are then submitted to the returning officer for the presidential election, chairperson of the first respondent, at the National Collation Center. This is an answer from the first respondent as to what is required to be done. If the witness is giving testimony that shows that that did not happen, my lords, that is obviously based on the pleadings. That testimony of the witness, that what she herself is saying she was required to do, that did not happen. How can that not be based on the pleadings? And my lords, in this court, counsel for both the first respondent and the second respondent have cross-examined extensively previous witnesses as regards the compliance. They have cross-examined extensively themselves. And in their cross-examination, they sought to put it to the witnesses of the petitioner that the chairperson had acted in compliance. That's their case. And my lords, if that is their case, again, our witness is able to answer those matters that they have alluded to. And so, my lords, in respect of paragraph 4, there has actually been testimony provided under cross-examination in respect of paragraph 4. So all that was read to you about additional and so on, which are well-known principles, matters have already been put in evidence matters have been put in evidence at the instance of both counsel for the respondents regarding what took place before the declaration. In fact, my lords, and my lords, this is really very critical. Counsel, especially for the first respondent, counsel actually put certain matters of fact to PW2, for instance, regarding that all he had testified to about leaving the premises of the Electoral Commission because they had been requested to do so was not true. And that, I mean, these were very serious matters put to the witness. What he said about the reasons why they left, the fact that they left their bags there, and I mean, they had no reason for leaving the bag. All that was stated in cross-examination to be false. All that. That was the case of the first respondent in cross-examining the witness, that everything he said was false in respect of the reason for leaving the place and so on. Well, how can it not be material in a determination of this case? How can it not be material for a witness who was there and who, in fact, if you like, played the lead role, because she's the one who went up and spoke and so on and so forth. How can his testimony about those matters on which they have already cross-examined, and they have put their case in cross-examination, and your lordships have also had reason, respectfully, to ask questions about those matters. I think your lordships asked questions in respect of Form 13. Your lordships asked questions in respect of why both of them had to go and not just one of them. I mean, evidence has been led in this court, particularly in the cross-examination of counsel for first respondent and counsel for second respondent. So, my lords, if there is testimony being offered which can corroborate the testimony, including, my lord, in that corroboration, as your lordships are well aware, in that corroboration, the witness is seeking to bring in a video recording of a representative of the second respondent in these proceedings, a video recording that he made at the time, contemporaneously, which therefore would actually give, additional third-party corroboration to the evidence that is being led. And my lords, in fact, respectfully, we were actually going to ask your lordship for that video to be played before the cross-examination. But of course, he's raised an objection, and we are dealing with that objection, after which we will do that. But my respectful submission is that where in their own cross-examination issues of the credibility of the witness have been raised, it is really lying ill in their mouth to come now and say to this court that a witness who, by all intents and purposes, is able to provide a corroboration should have the matters of corroboration that he's swearing to, that he's sworn to in this court, they should just be struck out. My lords, that cannot, with respect, be acceptable. And my lords, while I strive to avoid going paragraph by paragraph, I'm bound to refer to some of the specific paragraphs of this witness statement. The paragraph 5, where they are also seeking to strike out, so I will take the 4 and 5 in effect together. The paragraph 5, where the witness is saying that the EC had a video documentary person recording events in the strong room. And I have no doubt that if that documentary is available in its authentic version, it will confirm what I'm saying in this witness statement about things that occurred in the strong room. So, my Lord, what the witness is here saying goes directly to the issue of credibility and the availability of information, even in the custody of the first respondent, which can put the matter to rest completely in terms of the corroboration issue. So, my Lord, how can it not be? I mean, so the paragraph is basically saying to this honorable court, there is a video recording that was taking place. I'm giving you my account. If you have any reason to question any part of my account of what happened, there is a video recording. So the court itself can independently even order that video recording be produced, because we have, issues of credibility arising which we want to deal with. And it is my respectful submission that there can be nothing whatsoever in a witness seeking to underline the credibility of his testimony by making reference to an independent and available source of verification.
Prosecutor, I agree with you on the principle that, this is a civil trial, and it is based on the pleadings.
Yes.
And the paragraph 5 of the witness statement, now coming to talk about a video documentary.
Now coming to talking
about video documentary.
Yes.
This is the first time we are seeing this.
Yes, but my Lord,
the person is not a party. Mr. Nunumetel is not a party, he's a witness. So his evidence must take the form of the petition. The party himself, the petition is the claim before us. So he cannot come and introduce new facts.
My Lord,
that the petitioner did not even raise in the petition.
My Lord, with the greatest respect,
these are material facts.
My Lord,
it's taking us by surprise.
My Lord, it cannot take the first respondent by surprise. It cannot take the respondent by surprise, because the respondents were the ones seeking to cross-examine, contesting the accounts that had been given by other witnesses, especially PW2. They were contesting it. And what this witness is saying is that if you doubt my story, there is I observed that there was a video recording taking place. So that video recording can be resorted to by this court. Now, look, this court seeks to establish the truth of what different parties are putting before it.
The rules.
Yes, and the rules allow this court. The rules allow this court to have that independent source of corroboration, to have it available. The rules certainly allow that. The rules certainly allow that. And if witnesses of the petitioner are being confronted with allegations that what they have come to this court to establish is untruthful, and there is a video, for instance, that supports them. In this case, there is a video of Mr. McMenu, which he is seeking to put in evidence. There is a video coming from the EC itself, the first respondent. My Lord, I mean, it certainly is important for this court to consider. And
the video documentary in paragraph 5 is not what has been attached. It's not the video recording of whatever took place with Mr. McMahon.
I'm sorry.
Paragraph 5, yes. The video documentary there is not referring to the video.
Yes, but PW2 also testified to that video. It's in the witness statement of PW2. He testified to that video.
So you're in essence setting up a situation where you can ask for that video then? Is that what you're doing?
My lords, we are not necessarily going to ask for that video. What we are saying, we're not necessarily, my lord, it depends on the cross-examination, because if the cross-examination, and that I believe is why it is very critical that the witness has indicated that there was that video recording, similar to what PW2 also stated. So both of them have said, we are willing to have our credibility put on the line by reference to a video that captured what happened in the same way as the video of what second respondent's representative has said. So there is already testimony before this court. And my lords, I emphasize that that testimony came in under cross-examination, challenging the account. So second witness, PW2, said there was somebody taking video documentaries and so on. That evidence was not objected to. That evidence is before you. That evidence was not objected to, it is before you. And we are respectfully submitting that what is stated in paragraph 5 is no different from evidence that is already before you about the video documentary. And all that this witness is adding is that he is willing to put his credibility on the line, so that if anybody wants to have recourse to that video, they're entitled to. Now, my lord, depending on the cross-examination, we may indeed come before your lordship with an application that that video should be produced to the court and played, depending on the cross-examination. Because, my lord, we're dealing with a situation here where matters have been put to a witness in cross-examination extensively, and he has insisted, I'm telling the truth, this and that. And he said, there was this video. This witness also comes before you and says, there is a video. What I'm going to tell you can be tested. So, my lords, respectfully, not only do we have a basis in the pleadings of both the petitioner and the respondent, particularly first respondent, as I've indicated, where they are talking in paragraph 5, Roman 15. They're saying that this is what happens at the quaternary stage. The Form 12s are then submitted. The Form 12s are then submitted to the returning officer for the presidential election at the National Collation Center. And my lords will observe that that paragraph
you want counsel to address it on the paragraph 5, because you see, it appeared, both of them from the evidence were in the strong room.
Yes, my lord.
Yes, and if you look at the witness statement, yeah, there's nothing of this video documentary which yeah,
no, my lord, my lord, yes, but my lord, respectfully,
did he say anything about that?
Yeah, PW2. PW2 said.
No, in the witness statement.
I'm sorry, is your lordship referring to this witness statement? Dr. Professor White gave that evidence under cross-examination after he had referred to a video. He did, there is the reference to video is in Dr. Professor White's witness statement as well. Yes, my lords, I've just been reminded that it was actually under cross-examination when he was asked about journalists being present in the room. So when PW2 yes, I clearly remember, it was counsel for the first respondent who was cross-examining PW2. And counsel for the first respondent sought to put it to him that there were journalists present in the room. In effect, there were other people who could effectively also testify to the facts. And what we are submitting respectfully is that in paragraph 5 of this witness statement, what the witness is simply doing is to indicate a basis that can be used to corroborate his testimony, arising from the video documentary that took place. And my lords will observe that the issue of the video documentary is being brought in essentially on the basis of the credibility challenge that we have seen in this court, the credibility of the witness being challenged. And that is essentially what paragraph 5 seeks to do. And it seeks to do that because the witness statement is also entitled to provide testimony to contradict the case that the other side is making. Your lordships will be aware that the case that the other side, the case that the first respondent is making, the case is essentially that they acted fairly in all respects. And in fact, in that paragraph 5, Roman 15 that I referred to, first respondent is replying to paragraph 5, 6, 7 of the petition. My lords will see that in paragraph 20 of the answer of the first respondent, paragraph 20, it says, first respondent admits paragraph 5 of the petition only to the extent that it declared results at a press conference on 9 December 2020 and that it declared the winner of the 7th December 2020 presidential election was Nana Addo Dankwa Akufo, the second respondent, And then it continues in 21 to say, first respondent, in further answer to paragraphs 5, 6, 7, admits so and so. So, my lords, what I'm suggesting is that the first respondent has taken issue with the paragraphs in which the petitioner is raising issues about the first respondent's compliance with the Constitution and with the law, especially as it relates to that quaternary stage that is mentioned. First respondent is raising those issues. And if your lordships are going to be able to determine those issues, your lordships definitely want to have evidence of people who were in the room. But people are in the room and they come and they are going to tell different stories. So a witness says to you, your lordships, I was there, I saw so and so. But in addition, if you want corroboration of what I'm going to tell you, or if you want corroboration of what they are telling you, there is a video that was taken. My lords, that piece of corroborative evidence and the statement that that is available, that cannot be something that can be struck out of the witness's statement, because that's a fact. He is alleging it as a fact that there is a corroborative evidence available. My lords, after paragraph 5, we have paragraph 6. And in paragraph 6, again, this is a testimony about what happened in the strong room. That in that strong room, dedicated fax machines, printers, and computers were provided to receive faxes from fax machines at the regional collation centers in full view of agents of candidates, and then projected on an overhead projector in the strong room as the results were received. Well, I mean, this is evidence that is entirely based on the pleadings, because the pleadings raise the issue of what happened in the strong room before the declaration of the results. So paragraph 6 is entirely relevant. It's based on the pleadings. And my lords, I mean, it cannot be right that the witness statement's allusion to the availability of fax machines and the fact that those fax machines were not working part of the time, and one could see the frustration on the faces of many of the dedicated fax machine EC personnel and so on. My lords, that is evidence. It is obviously not something you plead. My lords, on the one hand, when your lordships pointed out to my learned friend that the objection is being made to evidence, not pleadings, he had to concede that that is in the nature of the. But in fact, when he actually talked about each of the paragraphs, he kept saying that it is not borne out on the pleadings. In other words, he expected to see in the pleadings the statements that the witness is making in the witness statement. And that is not how the rules of evidence and the rules of procedure work. Because, my lords, there is a very clear distinction made between pleadings and evidence. There is a very clear distinction made between pleadings and evidence.
Mr. Chikata, regarding these fax machines, which pleadings relate to it? Which pleadings relate to the evidence that you want to
The pleadings that relate to it, as I indicated, are from both the petition and from the answer. From the petition, starting with that, from paragraph 19 to 21, the pleadings indicate that she was required to act to comply with the Constitution. Then 20, that she acted in flagrant violation of the 1992 Constitution, and that she had a duty to act fairly, reasonably, and candidly. And then in paragraph 23, prior to her making the said declaration, Mrs. Gina Adukwe-Mensah had been notified by agents of certain material errors.
Mr. Chikata, you see, the problem I'm finding with this, your responses is that if you look at the entire petition, from paragraph 1 to the end, nowhere did the petitioner plead. Nowhere did the petitioner plead that he even had 2 representatives in the strong room. Nowhere.
Yes, but my lord, the petitioner is not required to plead evidence in respect
of... That is a fact. No, that is a material fact. That even as a candidate, had 2 representatives in the strong room to take care of his interests. And then they can come in now and testify and give evidence as to what they saw or what they did and what happened. Like in the petition indicating that even two
my lord, that is why I indicated to your lordships that in addition to what is in the petition, we have to look at what is in the answer. Because in the answer, the first respondent puts in issue the transparency and all that. The first respondent puts it in issue, as I indicated, and if she does that, the first respondent does that explicitly in paragraph 5. Now, the petitioner has to answer the case of the first respondent. The first respondent says in paragraph 5, Roman 15, starting from the beginning, the first respondent says, CI 127 sets out a 4-stage procedure for collating the presidential election results as detailed below. And this is an answer to what the petitioner is saying about acting in disregard of the law and the Constitution and so on. She says, this is the process that I followed. And she says specifically what should happen in the quaternary stage. The petitioner does that.
Now, Mr. Chikata, this whole trial, I don't see any issue brought to us regarding the process of the election.
No,
what you have brought to us is your difficulty with the declaration.
My lord.
And the import of the declaration. Is that not it?
No, my lord.
All right.
That is most certainly not it. My lord, if that were all, why would we plead paragraph 19? First respondent and his chairperson, Mrs. Gina Adukwe-Mensah, are required in the conduct of their responsibilities in respect of elections to comply with the Constitution. Why would we plead paragraph 21? First respondent and his chairperson are required by Articles 23 and 296 of the 1992 Constitution to act fairly, reasonably, candidly and not arbitrarily or capriciously, and to comply with the requirements of the law. Paragraph 23. Prior to her making the said purported declaration, Mrs. Jindra Adukwe-Mensah had been notified by agents of petitioner of certain material errors in the figures collated. That's not about the declaration. That's not about the declaration. That is about material errors that have been made. And the witness statement is drawing attention. The witness statement is drawing attention to how this paragraph 23, how was the paragraph 23 actually done? Because it says prior to her making the said purported declaration, Mrs. Jindra Adukwe-Mensah had been notified of certain material. So a witness statement which is describing how she was notified by the agents of petitioner of those material errors, that witness statement cannot be said not to be based on the pleadings, or paragraphs in that witness statement cannot be said not to be based on the pleadings. And my lords, I'm respectfully submitting also that it is not enough. It is not enough. It is not enough. It is not enough to. It is not enough to disregard the fact that the respondents have also put forward a case which the petitioner is obliged to answer. Now, your lordship said that there is no reference to the appointment of agents and all that. And I respectfully refer your lordships to paragraphs 6 and 7 of the answer of the first respondent. The first respondent says that CI 127 provides for the candidates to appoint polling and counting agents for the various stages, and that the respective candidates in the just ended election, including the petitioner, appointed agents who represented them at all stages of the electoral process as said above. So there's a clear pleading about the appointment of agents.
Yeah, Mr. Kijikata.
The answer
is not your pleading.
My lord,
you build your case on your pleading.
Yeah, but my lord, respectfully, that is where I'm pointing out that it is not sufficient in determining what is an issue to refer only to the pleadings of the petitioner, because the petitioner also has to respond to the case of the first respondent. The petitioner has to respond. In paragraph 5, in paragraph 7, the answer that first respondent gives is that first respondent confirms that petitioner indeed appointed agents and stationed them at all the polling stations and collation centers, and goes on in paragraph 8 to say that petitioner's agents signed 13 of the 16 regional election results summary forms, while the agents of the second respondent signed 15 of the regional election results summary sheet. I mean, these are pleadings which the petitioner is obliged to answer through his witnesses. The witnesses of the petitioner must put the facts that are within their knowledge, which contradict some of the answers that are provided, particularly answers about what happened in the strong room. And my lords, I was referring to what is clearly provided in Order 11, Rule 7 of CI 47, which in this context, I believe, is adopted, which says that subject to this rule and Rules 10 to 12, every pleading shall contain only a statement in a summary form of the material facts on which the party pleading relies for the claim or defense, but not the evidence by which those facts are to be proved. So, for instance, my lord, if you say the first respondent acted in flagrant violation of her responsibilities under the Constitution and under the laws which she operated under. If you make that pleading and the respondent comes and says, no, I acted entirely in compliance, and here's what I did. Here's what I did. Is it possible to cut off what's Can you mute? Actually, it's possible to mute from. It's possible to mute from the control. So, my lord, if our pleading is that she has not acted in compliance, she says, I have acted in compliance, this is what I did, we are obliged to provide testimony that shows that it's not the case. And we don't need to provide the testimony as if we are only limited to the exact words of the pleadings. The exact words of the pleadings that we are put in are that she acted contrary to her responsibilities in respect of the conduct of the election. We say so. And your lordships, with respect, requiring us to provide the evidence of that cannot be justified, because we have a situation where not only have we pleaded that, but the respondent in answer says, I did so and so, so and so, so and so, including I had agents, and your lordships yourselves asked questions. You had agents all over the country. Your lordships asked those questions, and answers were provided to them. The documents were given to your agents, and so on and so forth. Answers were given to them. And all that has been in evidence, not only without objection, but at the instance of the respondents. All that has been in evidence clearly. So if all that has been in evidence, it cannot possibly be said that that is not an issue in this case. It cannot possibly be said that. Now, my lords, yeah. In respect of the paragraph 23 of the pleading of the petition that I referred to earlier, your lordships will note that there is not only a reference to the fact that agents of the petition, and my lord, this is again a pleading which shows that we are referring to our agents. The agents of the petitioner took certain steps. Unless your lordship is wanting us to say agents were appointed by reference to a letter dated so and so and so. But we don't need to do that, because that is evidence. But we refer to the fact that the agents of the petitioner, who have also been referred to in the answer, they notified the first respondent's chairperson of certain things. And they go on to say that she refused to accept a letter written to her raising some of those concerns. So the actions of the agents in relation to what happened before the declaration, those actions are part of our pleadings. Now, my lords, I would refer further, and we are still dealing with paragraph 6, which they object to. I will refer further to the answer.
Order, please.
The answer of first respondent in paragraphs 16 and 17. In fact, if I may start from paragraph 15, where the first respondent says, first respondent adds that during the process and as the collation proceeds from state to state, any outstanding objections are addressed, paving the way for the candidates or their agents to sign the forms where they are present and are satisfied with the resolution. Then the first respondent goes on. First respondent adds that prior to the 7th December 2020 presidential election, it put in place a system to deliver a seamless and timely collation of results. First respondent is stating that it put in place a system. And that is the system that the witness is speaking to in paragraph 6. The dedicated fax machines, printers, those are part of the system. They are part of the system that is being referred to. And what the witness is doing is addressing the actual operation of the system from the 7th of December. So, my lords, it cannot possibly be something not born out of the pleadings, because their pleadings talk about, and then in paragraph 17, she says, first respondent says that numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow of the answer of the first respondent. Paragraph 17. He says, numerous requests for recounts at the polling stations and recollation at the constituency and regional collation centers raised by candidates and agents that were attended to in accordance with the rules governing the election did not allow for the prompt tallying and collation of the results as expected. My lords, in paragraph 6 of the witness statement, the witness is testifying to what actually happened and testifying in a manner that shows that this claim that is being made in paragraph 17 is actually not correct. It's not an accurate account of what happened in respect of the collation process. The witness's statement is directly contradicting that, because the witness's statement is referring to what happened in regard to the fax machines and their difficulties in operation. And in paragraph 7, which is also being objected to, in paragraph 7, the witness states exactly what happened, different, contradictory to what the first respondent is saying in response to the petition. The witness is saying that they say there were difficulties that were attended to in accordance with the rules. And the witness says, instead of that pre-arranged transmission system for the regional collation sheets to be transmitted to the head office of the Electoral Commission, what happened part of the time was that one of the deputy directors of the EC, that it should have been directors, but it says director. So Dr. Sribo Kweku would from time to time bring into the strong room what was claimed to be a regional collation sheet. How he got that sheet was not disclosed. My Lord, this is material testimony in response to what is stated in paragraph 17 of the answer of the first respondent. This is very material testimony. Because, my Lord, it really is serious if what this witness is testifying to happened as he's describing, as compared to what is required in CI 127. Because my Lords will notice CI 127. Yeah, CI 127. Yeah. So, my Lord, if there is an issue in this case, if there is an issue, facts about how recollation and issues raised by candidates and agents were attended to, and whether those were done in accordance with the rules governing the election, as they are claiming in paragraph 17, if there is an issue about that, with respect, the witness is entitled to give testimony that enables the court to know that what is being put before us is factually unacceptable. Now, my Lords will see also that in paragraph 27 of the answer of the first respondent avers that the presidential declaration form 13, which is a tally of the 16 Form 12s transmitted without the results from the Techiman South constituency, and showing the total votes cast and the total valid votes, shows that second respondent won the 7th December 2020 election. My Lords, PW2, the second petitioner's witness, stated in answer to a question from the bench that the form that was put, first of all, he said they never saw Form 30. That was his answer in earlier cross-examination. Then a question came from the bench where he was shown a so-called Form 13. And the witness stated categorically that that is not Form 13 under CI 127. That is material evidence of what happened. And my lord, that material evidence has gone in without objection. It was in answer to a question from the bench. And that material evidence shows that the first respondent's chairperson did not act in compliance with CI 127. That evidence is there on the record, and your lordships cannot turn a blind eye to a disregard of the Constitution and of the law that has come before you in evidence. Your lordships cannot turn a blind eye. And if evidence is being led, further evidence is being led, which shows the non-compliance, which we have pleaded, we pleaded that there was a non-compliance with statutes and the Constitution and the due process provisions and so on. If further evidence is being led that shows, for instance, that Form 13 is indeed not what is provided for by law, the Constitutional Instrument 127. My lords, that is very material, because your lordships are obliged to ensure that the law is respected, especially when it comes to a matter such as this. And in paragraph 8, in paragraph 8 that is being objected to. That paragraph says, my colleague Dr. Professor White and I, and that is a reference to PW1, on many occasions pointed out errors in figures and words on the sheets that were brought in, which ultimately affected totals and assigned results. This sometimes led to EC officials making phone calls on the basis of which they sought to explain and correct some of the things we pointed out. I cannot tell to whom those phone calls were made. I cannot tell if the calls were to EC officials or to some other people who were also involved in collation processes. There was no transparent process in this regard. My lords, this evidence about
Mr. Chikata, would the court of law have admitted the last paragraph? I cannot tell if the calls were made to EC officials or some people who were also involved in collation process. This is very, very speculative.
No, my lord, it's not speculative.
Somebody is talking on his phone.
You cannot tell.
My goodness.
Yes. But my lord, this is exactly what he said. He cannot tell.
So in the evidence, then you must as well leave it.
No, my lord, carefully. I'm not aware of why the witness cannot say. I cannot tell to whom the calls were made, because he said that they pointed out errors. When they pointed out errors, some phone calls were made. He cannot tell. And he answered by saying there was no transparent process, because essentially a transparent process would have involved making it known who you are calling, because you have to make it known who you are calling so that everybody in the room it's clear that your so-called corrections are coming from the right source. So, my lords, I fail to see why the witness saying, I cannot tell if the calls were to EC officials or to some other people who were also involved in collation processes. I cannot see what the objection is. Is the objection being made to some other people who are also involved in collation processes? Because your lordship said this cannot be in a court of law, and I want to. And my lords will see that the paragraph ends with a clear statement: there was no transparent process in this regard. And this again is in the context of paragraph 41 of the first respondent's answer, where the first respondent is saying, in a bid to enhance transparency and public participation in the electoral process, it published all the regional election summary sheets on its website. Your lordships will also see that in paragraph 37 of the first respondent's answer, what they are claiming is that notwithstanding all the resources and training deployed and the facilities put in place, there is a possibility of minor discrepancies as a result of computational and mathematical errors made in the course of the collation of results, but these did not have a material effect on the overall look. That is an allegation that is being made by the first respondent. That allegation cannot just be accepted on its face as being legitimate. That allegation will have to be proved in court by testimony that those computational and mathematical errors did not have a material effect on the on the overall result. That has to be proved. And we have a witness who is coming to court and saying in paragraph 8 that we pointed out errors in figures and words that were brought in, which ultimately affected totals and assigned results.
Please, you understood me. Because you see, if you look at section 63 of the Evidence Act, it says a witness may testify to a matter without proof of personal knowledge if no objection is raised by any party. Now, the court is at a loss whether this could have been raised in evidence. That was all. We were talking of the last bit of the deposition. So that was my worry, because if that evidence is being led in viva voce and it's not objected to, then it will go in. But then, when a legitimate objection is raised, that was my why I wanted to draw the court's attention to that.
Yes, but my lord,
that is under section 63.
Yes, my lord.
But you've gone beyond that, so let's proceed.
The evidence has been led under cross-examination.
No, I'm talking of the witness statement. That's our worry.
Yes, I cannot. Is it? I cannot tell. Yes, my lord, and that is why I was explaining that the I cannot tell is an account of what happened when they raised objections. They raised an objection. The EC official, and we are talking about officials, these are part of the informal interactions they were having. The EC official then makes a call and then comes back and tells them something. And the witness is saying in his witness statement, I cannot tell who the calls were to. And my Lord, that is a very honest, it's a very honest acknowledgement.
You don't have had any problem. But then it goes on. There was no transparent process in this regard.
My Lord,
this is the conclusion he seeks to draw.
Yes, because, my Lord, with respect,
because there was no transparency.
Yes, there was no transparency because, my Lord, respectfully, if we are dealing with certain figures, and I point out that there are certain errors in the figures that I've been provided with in sheets coming from officials. Those officials are in the room. Those officials are in the room. And they do not have answers. My Lord, respectfully, I believe this is an important point. And if I may be allowed to, if I may be allowed to complete my answer, because those questions that they are raising are obviously important enough, and the people in front of them who are EC officials are saying to them, we're calling somebody presumably to give us the information. So they call, and then they come back with certain answers. The witness is saying, I cannot tell who they called, and to the extent that I cannot tell whether those people were even EC officials or not, it does not amount to a transparent process. But that's a legitimate piece of evidence that the witness can give. And if on that basis the witness is saying that there was no transparent process in this regard, my Lord, that is perfectly legitimate. And my Lord, in respect of paragraph 8, yes, in respect of that, according to my notes, that is where it was claimed that, I think it's in respect of paragraph 9. Paragraph 9. In respect of paragraph 9, I believe that is where he says that your lordships have already ruled on the question of admissibility or of authenticity. That your lordships have ruled on authenticity, and this is being introduced by the back door. No, my lords, I cannot see how this witnesses paragraph 9. I cannot see how that can be said to relate to the ruling that your lordships made. Because, Councillor,
proceed, yeah.
So, I'm sorry. Yes. So in respect of paragraph 9, it is claimed that we are trying to introduce authenticity by the back door. Now, that is evidently not what we're trying to do, because your ruling on authenticity, your ruling on our application for the production of documents, your ruling did not say that no issues about authenticity can be raised about a document in these proceedings. Your ruling never said that. What this witness is referring to cannot be referable to that ruling. In that ruling, your lordships dealt with specific requests that we had made to the first respondent. Your ruling made reference to specific requests that we had made to first respondent. Here, The witness is speaking to specific documents that they had in the strong room. And the witness says, for instance, when we pointed out problems on the Eastern Regional Collation sheet, another one was subsequently brought in and claimed to be a corrected version. Obviously, that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. Now, the witness is making a clear deduction from one set of facts to another set of facts. The witness says, we had a regional collation sheet brought before us. We challenged certain things on that regional collation sheet. Then another one was brought in, supposedly a corrected one. And the witness is saying that obviously that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. Now, my lords, this again is clearly material evidence in support of pleadings which are challenging the claim of the first respondent.
My lords, if I'm with all due respect, I think counsel should read the whole paragraph, because the sentence that follows. Yes. Very well.
My lords, the paragraph of the witness statement says, obviously that corrected version could not have been what was produced at the Regional Collation Center at the time the collation was done, and was therefore not an authentic document. The only way to establish the authenticity of that document was for the original to be made available, and a transparent process undertaken in the presence of agents of the candidates for any corrections to be effected. Now, that is the evidence of that witness. And you brought me two documents. You said one is a correction of the other. In relation to the one which was available at the Regional Collation Center, my agent was there. And my agent can give me a report of what happened. In relation to what you are saying is a corrected one, I don't know where it came from. I don't have the original. I don't have a basis to accept it. That is what this witness is pointing out in this paragraph. I will move on after. Yes.
All right.
The
C'est très fan. Kojobi. 2020 de Mahameba. And the McLeod cause offer. I go for the bar with the share for 4 years, but now so then obey you. 1 is 3, 1 30. Scan the bar with your man from me. The penny about 2020, but soon yet in Quem. Abanadi Mahamafa. 2020, when you be on pre-cost, Hamafa. Abanadi Mahamafa. 2020, when you be on pre. Galam say was over Sebekina. Obano Kofa soldiers. Was the intimate now? What is this cavitas now? What's a sea low bed? Obebu, tell you betu. Then ya bro, I'm a need to. A pen of a partner said 2020, but soon yet in Quem. Abanadi Mahamafa. 2020, when you be on pre-cost, Hamafa. Abanadi Mahamafa. 2020, when you be on pre. Obano Obegu banks. I didn't say the kind of crime on Tiasia. I will bet my arm and I nice. I am Hukululu, Namashasi. Was Yasha and Tiasun Pilu. No better now, so the way any young. Amoya, and you plenty 2020 lesson. Yama chance. Hamafa. 2020, when you gun pre-cost. Hamafa. 2020, when you be on pre-share. Oh, my animal said dollar gunning. What's a mobile, tenasi, mobile dollar, Nayan Tabay, what you now on an Amuriasi. Salama family super incompetent, the American, no full evidence. The bank no way, before the way, set in Pama, Abanadi Mahamafa. 2020, when you gun pre-cost, Hamafa. Abanadi Mahamafa. 2020, when you be on pre-share, Koto Kraba market, why yeah. Keletia market in why yeah. Second overhead why yeah. Mahama E-blocks now man free SHS about Abanadi Mahamafa. 2020 when you be on pre-cost Mahamafa. Abanadi Mahamafa. 2020 when you be on Abanadi JMafa. JMbra. Abanadi JMafa. JMbra. Abanadi JMafa. JMbra. Can I deserve Abanadi Mahamafa. 2020 when you be on pre-cost Mahamafa. Abanadi Mahamafa. 2020 when you be on pre. Abanadi Mahamafa. 2020 when you be on pre-cost Mahamafa. Abanadi Mahamafa. 2020 when you be on pre. C'est très fan. Kojobi.
Ejo Bodo Tamalinku Koriansu Adewae Andise Joma Mae Andise Joma Mae Andise Joma Mae Tena yanka yube sapakemu Nisena yanka yube sapakemu Nisena yanka yube sapakemu Rabeji enu Rabeso yemu Rabeji enu Rabeso yemu na ye breo, ye breo, ye breo. 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 Rabeji yenu, rabeso yemu, rabeji yenu, rabeso yemu. Echo, bodo. Anana nyumre, ina bronco baby.
Statement. And the statement is made up of 32 paragraphs. Yeah, 32 paragraphs. And the second respondent's lawyer has raised objection to 23 of those paragraphs. And that's what you saw the petitioner's lawyer arguing out why those objections should not hold. The reason given by the second respondent's lawyer for raising that 23 objections on that 23 paragraphs of that 32 statement is that they were not pleaded for. As to exactly what those things actually mean, not going into the case itself, but some of these terms and some of these procedures. Our guest is still joining us, and Dr. Kweku Adjournment Budu actually, who is a lawyer, and he's also a law lecturer and the head of Law Center's Gimpa Faculty of Law. Doc, good afternoon.
Good afternoon, George.
And grateful for joining us. It's pretty been a very long one, though. Let's help us to understand the whole issue about witness statements, evidence, and what has been pleaded for.
Hello, I couldn't hear you.
I'm saying that one thing that has come out of this is that there's a witness statement, there's the evidence bit of it, and the argument of what has been pleaded for. Help us to understand how these three can be intertwined.
Okay. I think the first place that we need to start from is to there are a number of issues that we need to start looking at from on the list all that happened. Some basic public education on some of the things that I think will help us understand some of the things that are happening. So the first thing we need to understand is what pleadings are for the purposes of such proceedings. And because I'm sure you heard the court go on about pleadings, and some of the objections that were taken to the paragraphs or certain paragraphs contained in the witness statement, there was the objection to the effect that certain material had not been pleaded.
Yes.
And what was the basis? So the first thing we need to understand is what pleadings are. When we talk about pleadings in a civil matter, for instance, it refers to the things, essential things that information that you provide, the parties provide, which set out what their claims are, what are to those claims of that sort. So, for instance, the statement of claim is an example of a pleading, the statement of defense or counterclaim, if any, as well as the reply. These are all pleadings. And in the context of the presentation, the pleadings, or we can ascertain the pleadings from the petition itself and the amended petition filed by the petitioner, and the respective answers were given, or that the respondent filed in response to the petition that the petitioner filed. So those will be the pleadings. And one critical thing that we need to appreciate is that in your pleadings, you are to plead facts. In fact, the material facts that you believe will make your case are what must be contained in your pleadings. So if you noted that one of the consistent arguments of counsel for the second respondent was that the petitioner was seeking through his third witness to introduce things that were not necessarily pleaded, or it wasn't grounded, the particular paragraph wasn't grounded in the pleadings and things of that sort. So that's the thing that understand. The essence of has been talked about, for instance, the function of pleadings in an old case. It's called Hammond and Odoi. And I believe Justice C. Crab, JSC Accident was talked about the fact that by their very nature and fact, they demonstrate the importance in actions as for the benefit of not just the parties but the court as well. So the pleadings bind and circumscribe the parties and therefore places fetters on the evidence that they would lead, which is the next thing that I was going to get to. The fact that you plead facts, not evidence. But when it's your witnesses are called and testimony is to be given in support of your case, that's what you're going to do. You're going to make your case through your witnesses. The evidence that you introduce through the testimony of your witnesses must have basis in the pleadings.
Okay. All right.
So that was some of the things that we saw, some of the interactions that went on, where the arguments or the.
All right. Before you continue, help us to understand this. With the pleadings are usually found in the petition. Are they found in the petition?
The pleadings are, so essentially the paragraphs contained in the petition that the petitioner is saying, I am the petitioner, my name is so-and-so, I live at so-and-so, the defendant or the respondent is so-and-so, the address is so-and-so, on this day this happened, on this day this happened. Those are the pleadings. That's what we mean when we talk about pleadings.
Oh.
The material facts that are contained in the processes that you file, in this case the petition and the answers, which go to establish your case. So for instance, for a petitioner, your pleadings are contained in your the petition that you file, and you must allege all the material facts that in your view and in your opinion support the conclusion that you have arrived at, or the case that you're making before the court that so and so happened.
And what then is a relief?
What is the
a relief? A relief.
No, so the pleadings are simply the material facts that you are alleging, and then you know that the respondents will, in their answer, also respond to those, and those are also pleadings. They are saying, if I to the fact that my name is Asumesi or Bintini or whatever, but I deny paragraph so and so. All those are the pleadings that are in the case. So that at the end of pleadings, or by the time pleadings closes, there are certain facts and issues that are to the core of the case, which the court needs to resolve at that particular point in time. So the relief that you're seeking is endorsed on your claim that, and we saw that the petitioner in this case, for instance, is asking for a number of things. For instance, saying that there has to be the Supreme Court should compel or mandate the first respondent to conduct the second election between the petitioner and the second respondent, because on the basis of the case that they are making or that they will make, no one met the Article 63.3 threshold of more than 50% of the total valid votes cast in the election. Those are the reliefs that they are seeking. Now, one of the other reliefs they are seeking was an injunction to restrain the second respondent from holding himself out as president-elect or president, but obviously we've moved past that point because we know that the second respondent has been duly sworn in as president on the 7th January 2021.
All right, and so we are now on the evidence and linking that to the pleadings.
So for in terms of once pleadings are closed, like I'm saying, you then have the duty. So the one who, for instance, the party, there's a general understanding that there's a burden to produce evidence party, the burden of persuasion on a party, so that you need to produce enough evidence to make the case that you have, or substantiate the claims or the alleged fact that you have alleged in your pleadings, for instance. So and you need to introduce sufficient evidence to avoid a ruling on an issue against you, generally speaking. So in an election petition or in any civil case, there's a burden to produce evidence, which is on you, the party that is alleging a particular fact, the existence of which you're bringing in evidence, or you're leading evidence to substantiate that particular fact. So you need to produce sufficient evidence, which on totality of the evidence will lead the court to the conclusion that the existence of a fact was more probable than its non-existence. So the burden is on the one who is alleging certain facts or making certain allegations to produce evidence which is substantial enough to lead to that conclusion. Obviously, we know that sometimes the evidential burden shifts. So the burden of proof generally in a civil case at all times is on the party that has brought the claim or making the claims. You need to, on the balance of probabilities, establish your case, or that your case was more probable than not. But the evidential burden sometimes shifts from one party to the other party. So that, for instance, if a party has adduced evidence which is substantial enough on a particular claim, the evidential burden may shift to the other party to also lead some evidence that will probably contradict that which the other party has done. So these are that can happen in terms of the evidence that can be adduced during the cases and things of that sort.
All right, and so in other words, the witness statement should go according to, or should actually sync with your pleadings.
The bottom line is the facts that you have pleaded in your petition, in this instance, or in the statement of claim, or other pleadings in other civil cases. Those facts are the ones that are going to be, or you have to prove through evidence. So if you say, for instance, that George Sappor was on TV or was at the studios or premises of GBC on 5th February 2021, that is a fact, right? That you are stating in your pleadings. When it comes to the testimony and in terms of adducing evidence, you should be able to produce evidence that will substantiate that fact that you have stated, or the alleged fact that you have articulated in your pleadings, that indeed George Sappor was with the premises of GBC on 5th. But you have not pleaded a particular fact, but you seek to introduce evidence subsequently in the testimony of your witnesses or witnesses, which leads to the conclusion that you are
Look, we're having some bit of challenges with your line there. What we're going to do is that it's just also time for us to go for a quick break. So whilst you're going for the break, we work on your line there and get back to you shortly right after the break. If you're just joining us, this is Ghana Television. This is also GBC News. This is Unique 95.7, and also across the 16 regions of this country, and various regional FM stations and community radio stations of the Ghana Broadcasting Corporation. We are live on Facebook, Ghana Broadcasting Corporation, and on internet, gbcghanaonline.com is our coverage of the 2020 presidential election petition. As we speak, the judges have taken a bit of recess, going to determine the 23 objections raised on the witness statement of the third witness of the petitioner. And that statement has about 32 paragraphs, and the second respondent has raised objection on 23 of those paragraphs. Stay with us. We're going for a quick break. We'll be right back. Don't go anywhere.
Mahama,
just quickly work on that bit, sir. Okay, look, again, in proving all these things in your witness statement as you have pleaded for, should it be something in the statement that clearly goes that, I mean, these are things you've pleaded for, or you can actually also argue your way out?
I'm sorry, George, I can't really hear you that well.
Okay, is it better?
No, it sounds very far away.
Okay, we'll try as much as possible to work on that and get back to you. Dr. Kwekwa Ajiman-Budu, who is he's a lawyer, is a law lecturer. He's also the head of the law centers at GIMPA, the Faculty of Law there. We've been talking to him since the judges went on a recess to determine whether to grant those objections raised by the lawyer for the second respondent. As I stated earlier, the petitioner has a third witness, and the third witness is Rojo Metal-Nunu. And in the third witness statement that is made up of 32 paragraphs, the second respondent's lawyer has raised 23 objections to those 32 paragraphs. So paragraph 4, 5, 6, 7, 8, 9, 10, 11, 12, then 15, 16, 17, 18, 19, and went further to paragraphs 20, 22, 23, 24, 29, 25, 26, 30, and 31. For some of the paragraphs, it seeks to strike out some parts of the lie, like paragraph 4, and that also of paragraph 15. That one not necessarily striking out the entire paragraph, but striking out some portions of the paragraph. The lawyer for the petitioner had to argue out why, to them, those paragraphs are important and why it need not be struck out. Well, the judges have taken a recess now to determine whether or not to hold up to the objection or not to hold up to the objection. Let's see and go back to Zoom and see if we have Dr. Kwekwa Ajiman-Budu, who is back. Doc, I hope this time around is better. Hello, Doc. All right, we have to go for a quick break and we'll work on this line and get back to you. Stay with us.
Raised in respect of paragraph 10 of the witness statement, where the witness is stating Again, in respect of what happened in the room, some of the time, when the officials of the EC said they were correcting, in quotes, errors, their officials had already signed the regional summary sheets, and yet they accepted that corrections were needed. At other times, when we queried certain collation results from the regional levels, they were quick to say, once your representatives have signed, the only relief available to you is to go to court. Now, my lords, again, that is evidence about what happened in the room. And my lord, that evidence, again, has to be read in the light of both the averments made by the petitioner in his amended petition and the reply and the answer that is given. And now, my lords, I respectfully draw your attention in particular to paragraph 40 of the reply. The answer of the first respondent. Paragraph 40. The first respondent says, in further denial of the petitioner's claim, it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias against anyone. This is the pleading of the first respondent, that they conducted in compliance with all the processes and procedures laid down by law. Now, my lord, respectfully, your lordships have almost all, sometimes professors are allowed to jump certain hoops, but almost all of your lordships, as trial judges, have had occasions where the plaintiff's witness is in the witness box giving testimony. The plaintiff's witness is being led by counsel. And in the course of being led, the plaintiff's witness will have read to him pleadings of the defendant. And the plaintiff's witness, for instance, in this case, if I were leading him in evidence, I would say to him, you have seen that in the answer of the first respondent, they say, in further denial of the petitioner's claims, first respondent says it complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election, with fairness to every candidate and without malice, ill will, or bias against anyone. So I would read this to him in evidence in chief, and I would say, what do you have to say to that? And that witness would testify to give his account contradictory to the account, Now, so my lord, my submission is that in every context in which the witness statement effectively is answering claims made by the first respondent, or for that matter, the second respondent, and we'll come to the second respondent's answers. But in every context where the witness statement is a response to that, position of a respondent, the witness statement is entirely permissible. That evidence is permissible. And it's permissible in evidence in chief. So, my lords, it is in the same way that all my
it will be fairly long because we understand the health conditions of the potential witness and the fact that when we were coming to say, we didn't anticipate this objection, which obviously is attracting these lengthy submissions in answer. Yes, so therefore, we are discussing whether if it is possible for us to entertain the submissions from you, but we will ask them to come back so that Monday, hopefully Monday, he may even be better, so that we can take the cross-examination on Monday.
Very well. So that the witness...
We have absolutely no problem with that.
Yes, Mr. Menuvo.
Very well. So
agreeable. So I can instruct them to get them back.
So the witness, yes, the witness.
Yeah, but we will still continue to have it on Monday. I'm talking of the link.
Yes.
Yes. On Monday.
Yes.
Okay.
Very well. Very well. But what I'm saying is that I take it then the witness doesn't have to remain.
Yes.
And the registrar can also then come.
Yes. Yes.
Because I was thinking of what the registrar will have for lunch.
Mr. Chikata, I thought you had made provision for some sumptuous lunch for him where he is.
My Lord, I was inclined to make provision, but at the risk of it being thought that I was trying to influence. No, my Lord, seriously, during the break, I raised a question with one of my colleagues, whether it would be appropriate, and we decided that let's not allow my good friend Cheche to raise.
He's there with an escort. So he's there with a police escort. So he also needed lunch.
There we go. No, but if your lordship will allow me, I'm perfectly, and if my good friend. But you know that is truly. I mean, it's we're. Very well. Thank you.
Thank you.
So, my lords, it's my submission that the objection that was raised to paragraph 10, that we are attempting to build a new case after cross-examination, that objection is unfounded. Because all we are doing is to do what is a normal practice in trial courts, where a witness can always be asked. This is a paragraph in the statement of defense. What do you have to say to that? And that goes on day by day in all the trial courts of Ghana. I cannot see how anybody can suggest that that practice is somehow an attempt to build a new case after the cross-examination of a previous witness. I cannot see that. Because with each witness, counsel leading an examination in chief is entitled to put to the witness the case of the other side. Now, my lords, and it is important in this connection to put further aspects. I was loath to put so much of what is in the case of the other side. But in the nature of this objection, I think I would be doing an injustice to the petitioner if I did not detail how it would have been done in a normal trial court process. Because my lords will see that in paragraph 38, for instance, of the first respondent's answer, the first respondent states that after the declaration of 9th December, 4 constituencies in the Greater Accra region reported an update in the results announced in those constituencies, a net difference of 1,651. That update was factored into the 10th December 2020 press release, but it did not have any material effect on the overall results as declared. Now, my lords will see that not only in paragraph 10, but also in paragraph 12 of the witness statement, the witness states, "It is my express understanding that the entire election processes require, importantly, a transparent assembling and collation of results so that no single vote of those who cast valid votes is left out of account, and not one invalid vote is included in the votes taken into account. It is also my understanding that nothing other than votes cast validly at one of the accredited 38,622 polling stations should be factored into the collation at the 275 constituency collation centers through to the 16 regional centers and on to the EC strong room. At each stage, evidently, corrections could be made in accordance with due process." That is testimony that the witness can legitimately give in responding to paragraphs 30, 38, 40, and other paragraphs in this. In this first respondent's answer. And your lordships will also notice that in paragraphs 13 and 14 of the first respondent answer, the first respondent says further that at each stage the candidates or agents present are given a duplicate carbonized copy of the summary sheets, namely Form 8B, Form 10, and Form 12. 14. First respondent adds that there is therefore one original of each summary sheet with as many carbonized duplicates as are issued out by the officer in charge at each stage. So my lords will again see, if I may make a reference back to the last comments that I made in respect of paragraph 9, your lordship will see that those comments or those statements in the evidence about only one document being actually the document that should be provided, they are reflected in paragraph 14 of the answer of first respondent, where it is stated there is therefore one original of each summary sheet with as many carbonized copies. So when you are presented as they were in the strong room with two, which were supposedly the same region, and they are presented with two, the witness is perfectly entitled in responding to that to say there can only be one. You yourself have said so in your answer. And therefore, if I'm presented with two, there's a problem. And we need to get to the heart of the problem. My lords, it is also worth bearing in mind, and again, I do not say it as a criticism of CI 99 or anything, but it is worth bearing in mind that just in the nature of what CI 99 provides for, as far as election petitions are concerned, after the answer, there's no reply. So, unlike the scenario where in the normal process under CI 47, in a reply, you can respond to certain statements or certain pleadings. In the case of the election petition under CI 99, there's no opportunity for a reply. So your only opportunity is in doing what I respectfully refer to, which trial judges do the whole time, of saying that I'm putting to you this case, what is your answer? That's the only opportunity. And I'm respectfully submitting that that is, again, an important consideration that should guide the determination of the scope of a witness statement that is effectively evidence. Essentially, everything that a witness can say legitimately in evidence in chief in support of the statement of claim, everything should be admissible, subject to other kinds of objections in terms of, and Malone, there is no issue here about relevance. It has not been said that these matters are not relevant. There's been no issue. Now, my Lord did make a reference to Section 60 of the Evidence Act. And just to be sure that I understood fully the point that was being made. It says that a witness may testify to a matter without proof of personal knowledge if no objection is raised by anybody. Now, in this case, we are not talking about a witness who is giving testimony without proof of personal knowledge. The witness is saying, I was there. And he's testifying with proof of personal knowledge.
Understand it. My worry was with the paragraph 8, where he was talking of the fact that they were talking to some people on the phone. He couldn't hear them, but then he concluded that there was no transparent process.
So, yes.
In that regard, that was my worry.
Right. So my Lord, all I'm saying is that to the extent that he is giving evidence about what he was witnessing, what he had personal knowledge of, to that extent, respectfully, I do not think that section affects the testimony that he is giving, because he is there, he is hearing a conversation. He doesn't know who is at the end, and so he's saying to the court, I don't know who is at the end. So, my Lord, I believe that section really will not be applicable in a situation of the witness having personal knowledge of everything that he is describing in the strong room. Now, my lords, I believe that the next is paragraph 11. And my lords, it is again a bit strange that we are being asked to take out a witness describing circumstances under which he signed a certain document. He signed a document. He said, I must admit I was misled. And this is linked to what is in verse, paragraph 10, not verse 10, paragraph 10, where he says, the election official, the EC official were quick to say, once your representatives have signed, the only relief is to go to court. So the witness says, I must admit, I was misled by this position of the EC officials into signing the regional coalition sheet for the Ashanti region simply because there was a signature of the agent of the petitioner at the regional coalition center on that sheet. I later found out from speaking with officials at the party headquarters that what had been presented on the signed collation form was not consistent with a tally of polling station results in the Ashanti region. That is his evidence. And he is bringing that evidence to explain, on the one hand, why he signed, and on the other hand, why he later raised an issue. So, my lords, that also...
I think he went further, if my notes is correct. He went further to submit that since he was talking of being misled, there was the need for particulars. Yes.
My lord, with respect,
I think that was his submission.
My lord, this is not a pleading.
Yeah.
It's not a pleading.
Yeah, he was alluding to that. Then we said it was not a pleading, it is not a evidence. Mm-hmm.
Exactly.
So the particulars was not necessary.
Exactly. So, my lords, with respect, I would adopt the wisdom of your lordships on that matter. In other words, my lords, it cannot be an objection. It cannot be a basis of objection to something that clearly could have come in evidence in chief as to why he signed. In fact, again, this is a matter on which cross-examination has already taken place. PW2 was cross-examined, and his attention was drawn to the fact that Mr. Metsonuno actually signed. And so, Mr. Metsonuno is now a witness, and Mr. Metsonuno is explaining exactly why he signed. That cannot be legitimately objected to. And I believe I have already, in effect, addressed paragraph 12. And in relation to paragraph 12, I had made reference particularly to paragraph 40 of the petitioner's, of the first respondent's answer, where he says, in further denial of the petitioner's claims, first respondent says that he complied with all the processes and procedures laid down by law for the conduct of the 7th December 2020 presidential election with fairness to every candidate and without malice, ill will, or bias against anyone. So what is in paragraph 12 is clearly a response of the witness
that the witness was stating an opinion.
Okay.
That was what my records...
of paragraph 12?
From paragraph 12, yes.
Okay, my lords, clearly...
not on facts.
Clearly it is not... It is not an opinion. It is not an opinion, and my lords, here again, I believe that the first respondent's answer is quite clear that what is being stated here is precisely what first respondent recognizes to be the responsibility of the first respondent. And that is not only in the pleadings in paragraph 5, but it is also in paragraphs 9, 15, and 16. Of the first respondent's answer. In paragraph 9, first respondent is saying it also engaged officers to work as regional collation officers, constituency returning officers, and presiding officers to enable it to carry out this constitutional mandate. And in fact, paragraph 7 and 8 all explain exactly what the testimony relates to. The testimony is saying the entire election processes require, very importantly, a transparent assembling and collation of results, and so on and so forth. That cannot be an opinion. And my lord, it cannot be an opinion also when your lordships refer to regulation 4410. Regulation 4410 of CI 127. Regulation 4410 states, the chairman of the commission shall, on receipt of the presidential regional result summary sheets, as set out in Form 12, and that is what is referred to in the first respondent's answer as I referred to. And the paragraph says, the regulation says, as set out in Form 12 of the schedule, from the regional collation officer, in the presence of the public, and with not more than 2 counting agents appointed by parties contesting, or the polling agents of the parties, if any, assemble and collate the presidential election results from the regions provided by the various regional collation officers are set out. So what the witness is stating in paragraph 12, what the witness is stating about the entire election process requiring a transparent assembly and collation of results and so on, that is effectively a reference to what is required to be done under Regulation 4410, including the filling of the declaration 4410A-B, and then C, requesting the representatives of the political parties to sign the declaration of presidential results form and so on. All that is provided for there. And that is what the witness is talking about. It's not an expression of opinion. It's an expression of what is required to be done. It is an expression of what is required to be done, and evidence is then provided on the basis of that. So my lord,
irrebuttable presumption.
My lord,
yes,
I think that this witness is providing a basis for other statements that the witness makes. If your lordships are inclined to regard it as a matter of law and so on and so forth.
Because basically it's from the regulation 4410.
Yes.
Basically.
Well, but my lord, it goes beyond,
substantially.
It goes substantially. Substantially it is. Substantially it is. But my lord, the reason why it is relevant here is because there's been an indication that when they made challenges to certain forms in the context of what was going to happen in the collation process, those challenges were set aside. And I believe that that is the context in which the witness is pointing out, that they are being set aside in the manner that was done was not in accordance with this. I think that in the context of this witness statement, that is what the witness is doing. The witness is alluding to the requirements in order to show that what was done to them when they were so the witness is alluding to this in order to show that what was done to them when they queried collation results from the regional levels in paragraph 10, what was done to them was not in accordance with what the witness is saying is required in paragraph 12. Now, your lordships indeed can recognize that substantially this is in terms of what is in regulation 4410. The witness puts it in as a backdrop to what he's saying about what they were denied in the room. Now, my lords, there is in my notes, the next one is paragraph 15. So I take it that paragraphs 13 and 14.
Yeah, paragraph 15, he compares with a portion where both could not be authentic up to the latter part. He never attacked the whole of paragraph 15.
And not paragraphs 13 and 14 either.
Paragraph 13 and 14
right.
Are not in contention.
Yes, my lord.
Okay.
So, my lord, paragraph 15, both could not be authentic. My lord, respectfully, as I've indicated, paragraphs 13 and 14 of the answer of first respondent are clearly paragraphs to which this part of the witness statement ought to be referred. Because in those paragraphs, the first respondent actually says further that at each stage, the candidates or agents present are given a duplicate carbonized copy of the summary sheets, namely Form 8B, Form 10, and Form 12. So they're given, according to this, carbonized duplicate sheets. Then 14, first respondent adds that there is therefore one original of each summary sheet with as many carbonized duplicates as are issued by the officer in charge. So there is one. So, in paragraph 15, having said, in respect of the Eastern region, 2 separate summary sheets were sent to the EC strong room, the witness says both could not be authentic. My lord, I mean, that is a clear reference to the answer of the first respondent saying that there is only one original. So if you're given 2 documents in respect of the same region and there are differences between them, both cannot be authentic. The witness is stating that as a fact. And that is something that your lordships are going to have to consider in the context of whatever evidence there. If the first respondent in their testimony is able to explain how, in spite of what they themselves say about one original of each summary sheet, one original, they say so in paragraph 14. So if they can come and explain to this court how, in spite of that, the witness found himself presented with two separate summary sheets, and he says both could not be authentic. Only by getting the originals of these documents can there be a clarity on exactly which is the genuine form from the region. That is an important factual statement that the witness is making. You cannot have, according to even the first respondent's own paragraph 40, you cannot have more than one original. So how do you suddenly have two different things that are reflecting different numbers and so on? How do you have that? So in paragraph 15, what the witness is saying in the passage that they seek to have struck out is, in our respectful submission, entirely permissible. And my learned friend appears to have an impression that, we are just going back to rulings of this court and so on about authenticity and all that. And I think that we need to disabuse his mind of the fact that we know how to conduct our own case. And if we wanted to go back to the issues that were dealt with in your ruling on the request to produce documents, I think we know the processes by which we can contest that ruling. So it is not by any stretch of the imagination, it is not in this witness statement that we are going to go back to a ruling that your lordships have made about authenticity of documents. What is being put in here by a witness has nothing to do with the ruling that your lordships gave in respect of the application about authenticity of documents. In paragraph 16, again, your lordships will see that what the witness is actually saying in paragraph 16 is extremely pertinent to paragraph 38 of the first respondent's answer. Because the witness in paragraph 16 is saying, in respect of the Greater Accra region, we observed that the total votes given to the petitioner, which is meant to be based on the sum of all constituency votes, on the face of the regional summary sheets presented, was less than his actual total. Well, that's a very important statement of fact. We also observed that the regional summary sheets published by the EC, while the process was ongoing, had different figures compared to the one given to us in the National Collation Center. And my lords, as I'm suggesting, if you look at paragraph 38, my lords, if you look at paragraph 38 of the first respondent's answer, it is quite clear that in respect of Greater Accra, there were a number of issues to which the witness is entitled to provide factual testimony. Say in paragraph 38, first respondent says that after the declaration of 9th December, which after the declaration of 9th December, 4 constituencies. So first respondent is trying to give an explanation, in effect, of some of the issues related to Greater Accra, about which, again, your lordships had a lot of cross-examination of petitioner's witness. First respondent here says, after the declaration of 9th December 2020, 4 constituencies in the Greater Accra region reported an update in the results announced in those constituencies, a net difference of 1,651. That update was factored into the 10th December 2020 press release, but it did not have a material effect on the overall result as declared. This is what the first respondent is seeking to provide by way of explanation. How can it not be permissible for the witness of the petitioner to give his account of the problems that they encountered in the strong room in relation to the collation? Because by this time, the declaration had not taken place. And so whatever steps needed to be taken to ensure a proper collation, the witness for the petitioner and his colleague were seeking to have these matters addressed beforehand. And my lords, I mean, this makes his evidence even more germane in terms of the issues in this case, because the issues relate to the 9th of December declaration and the fact that effectively there is an admission by the first respondents that yes, there is an error in respect of what we stated to be total valid votes cast. That is their case. That yes, we admit that there is an error, and we sought to correct it the next day. And they are providing in 38 further explanations of how they sought to make the corrections and so on. The witness of the petitioner is saying to this court what happened in respect of the very region where they acknowledge in paragraph 38 there was a problem, and saying that this is actually the fact. I think that testimony is directly relevant to the issues that are being addressed in paragraph 38. And if it were in a trial court proceeding, as I've indicated, one would directly put to the witness, this is the paragraph in which they are talking about Greater Accra. What do you have to say about that paragraph? And that witness will be entirely within the bounds of legal processes and evidence to then say exactly what the witness says in paragraph 16. This is what we observed about the total vote in Greater Accra. This is what was wrong. In paragraph 17, my understanding is that it's from the second sentence. Yes, that was one of the things in respect of which we asked the party headquarters to have the election directorate go back to the polling station level data to ascertain what the correct figures were. We were waiting to get feedback on that, among other things, when we had the declaration of results by the chairperson of the Electoral Commission. These are agents of the petitioner who were conducting their responsibilities under CI 127 as they were duly meant to do. And they are indicating to the court how they conducted those responsibilities, not only as representatives of their party, But essentially, as part of the nation's eyes and ears, and I guess hands and feet as well, in respect of this election. And they are saying that this difference, this particular difference between the regional summary sheet presented in the strong room and the one published on the EC's website has had no explanation provided for it. And that was one of the things in respect of which they asked. Now, my lords, in paragraph 41 of the first respondent's answer, they claim that in a bid to enhance transparency, they published the election summary sheets on their website. Now, my lords, this witness is saying there were inconsistencies that we found in respect of these things that you have now posted on your website. And you did not provide an appropriate explanation for them. So it does not enhance transparency if you publish things that you have arrived at in a non-transparent manner, and then you say it enhances transparency. You didn't allow these matters to be dealt with in the context in which they had to be dealt with. Then you are saying that after the event, you publish those things, and that enhances transparency. My lords, I cannot for the life of me understand how you fail at the point where you are required to be transparent and to engage these agents with the appropriate answer. You fail to do that, as is being alleged. And then you're saying that they can't come to court and say, these are matters on which I try to get the correct information in order to use to ensure that the transparent thing was done. Why can they not say to this court, that was one of the things in respect of which we asked the party headquarters to have the election directorate go back? Because, my lord, what is assembled and collated at the national level, as we have in fact heard many times in this court, comes from the polling station level. So if the witness is, again, drawing attention to what he sought to do, what he and his colleagues sought to do, in order to ensure that they could be effective participants in this process, I cannot see how that can be a basis for an objection to his. And my lords will notice that the witness says in the last sentence of paragraph 17, we were waiting to get feedback on that, among other things, when we heard the declaration of results by the chairperson of the Electoral Commission. We were waiting. So they've raised an issue. And in the interest of transparency, they're waiting for a response. And all they hear is that a declaration has been made. Now, my lord, I cannot see how, in a situation where the issue of transparency is being contested, in the lack of transparency is an issue here. I cannot see how the witness is not allowed in his witness statement to deal with this matter. Now, in respect of paragraph 18, there again, my lords, I think I will just abide by the response that I gave in respect of paragraph 15, because I think it is the same issue about authenticity and whether we are trying to go by the back door and so on. My lord, I always prefer to go by the front door. And I do not think that anything that we've done in this court in terms of the processes with which we have sought to address the court's rulings suggests that if we are dissatisfied or if we want to confront a court's ruling on authenticity.
This is a repetition. We've taken notice of it.
No, my Lord, this is a different paragraph, and I'm saying that I'm adopting what I said.
Yes, yes. So it's okay.
So this is a different paragraph. I have not addressed this paragraph.
No. What you said was that you were adopting the reply on the authenticity, which you copiously raised in paragraph, I think, 15.
Now in paragraph 19, here again, the witness is talking about something that he did, which he found to be an error. There had been a complaint duly made. And maybe, my lords, again, I will take it with 20. I'll take it together with 20 so that, yes, I'll take it together with 20 to because both relate to this business about making a mistake and so on and so forth. And the witness is basically explaining the fact that there was something that he signed at this national level, and he missed the fact that at the regional level,
the summary sheet. Yeah, instead of the something that he claimed to have signed.
In 19.
19, yes.
When I signed the summary sheet.
That's right.
Yes.
That's right.
That's right. He said, at the time I signed, I missed the fact that the agent at the Regional Collation Center had stated clearly the reason for not signing. So in other words, there was a reason given by the agent, again in accordance with the rules. The agent actually gave a reason. And the witness is admitting that he missed that and he signed. And they made the officials aware that the agent at the collation center had not signed and had given a reason. And so he says in paragraph 20, I would have pointed out my mistake to the chairperson of the EC if she had come for the process of assembling and collating results as she was required to do. So the witness is acknowledging an error and recognizing that there was going to be an opportunity for him to put forward the fact that there is a complaint. Let's deal with a complaint. That's what the witness is doing in this case. In any case, officials of the EC, being aware of the reason given on the form by the agent, could not just disregard it and claim that once I had signed, the matter was closed. My Lord, if we were to be dealing with the fact that, or with the suggestion that once you sign a document, it is sacrosanct, I mean, frankly, we would have perhaps, you know, had some very serious issues with all the changes and amendments and press releases and all that. But that is not the issue here. The issue here is that this witness is openly acknowledging, I missed something in the documentation. The EC officials knew that it was there, I missed it, and I would have brought it up if the opportunity arose. So we cannot see how that should be taken out. In paragraph 22, the witness states, it was in the light on the experiences. I'm sure that it must be off, but it was in the light on the experiences, what's there, of different regional certification processes and the posture of the EC officials in the strong room on 9th December 2020, that on behalf of my colleague and myself, I sought to consult with the chairperson of the EC, the returning officer herself. So, my lord, he is testifying to why he sought to consult with the returning officer. And he goes on to explain that he needed to receive feedback on what he had conveyed to her the previous day. Particularly as I learned from officials at the NDC headquarters before I got to the EC headquarters on 9th, that there was likely to be a stakeholder meeting of key players in the presidential elections with participation of local and international observers, media and civil society groups, and the EC to address concerns that the NDC addressed. Well, all this is evidence in respect of what matters had arisen in the strong room which he sought to take up, and which again provided the context of his meeting with the chairperson of the EC. This was testified to by Dr. Professor White. No objection was raised when it was testified to by Dr. Professor White. Is it that one of them has doctor before his name and the other doesn't have doctor? That cannot be a basis for legitimately objecting to Mr. Roger Metul-Nunu, Mr. Robert Joseph Metul-Nunu, testifying to matters which were accepted without objection when Dr. Professor White testified. There cannot be a basis legitimately. There cannot legally be a reason for the differentiation between what happened in respect of Dr. Professor White and what is now happening in respect of Mr. Metul-Nunu. My lord, in paragraph 24, which is also being objected to, and my lord, that is deceit. This was something about deceit. This was something about deceit, that we are talking about deceit. My lords, in none of the paragraphs 24, 29, 30, 31 that my learned friend referred to, in none of those paragraphs is there any allegation of deceit. There are factual statements being made. Paragraph 24, the witness says, I was also struck by the fact that she proposed that she would send a dispatch rider to help us to get back to the headquarters of the EC ahead on time for her own exercise of her responsibilities. There was nothing in the discussions which could have given me any reason for doubting the word of the chairperson of the EC. Indeed, having worked with her previously when I was a consultant to the IEA, I had no reason not to trust her. No, I mean, this is not an allegation of deceit, it's just a fact. I had no reason not to trust her. So when she said so and so, I did so and so. That cannot be an allegation of deceit. Now, my lords, we can draw inferences about deceit. Yes, we can draw inferences, but there's nothing in the witness statement where there is an allegation of deceit. And indeed, in the witness statement, as your lordship said, these are not pleadings. So it's not as if, there's a pleading of deceit, and then there have to be particulars provided and so on. That's not the nature of what we're dealing with in this witness statement. My lords, again, it is significant that in the case of Dr. Kwesa White, he stated under cross-examination categorically that he felt they had been deceived. He did say that. Dr. Kwesa White said that. He stated that. He felt that they had been deceived. Now, and he stated that in response to questions in cross-examination. But what we are dealing with here, respectfully, is evidence in chief of this witness. And he has not made anything on the basis of which it could be said that some pleadings should be amended for further particulars. And my lords, I would want to respectfully submit that in 24 as well as, and those, obviously there is relevance in all this, and it is quite clear that it is the powerful relevance of all these statements that the witness is making in the witness, the powerful relevance of that the respondents are seeking to run away from. Because, my lord, it is powerfully relevant.
Please, the language is too tough in a court of law. They cannot run away from.
My lord,
no, please.
May I just, I will restate.
That's right.
I will restate the point that I want to make in the following manner. There is no doubt that the testimony that is contained in paragraph 24 is powerfully relevant to the issues in this case. There's no doubt about that. It's powerfully relevant to the issues in this case. And what my learned friends, in my respectful submission, what they need to address is whether those statements are true or false. And those are matters which will be dealt with in the context of the further proceedings in this court. So your lordships will have the opportunity to assess. You'll have the opportunity to assess whether what this witness is saying is truthful and therefore relevant in the powerful way that I'm suggesting to a determination of the matters before you. Now, my lords, again, in cross-examination, Dr. Kwesa White testified to these matters. There was a dispatch rider going to be sent and all that to help them get back to the place in time. Dr. Kwesa White has testified to these matters without objection. Why are we confronted with an objection when it's Mr. Metalnuno who is testifying? More. And below, we underline the fact that Dr. Kwesa White testified in cross-examination at their instance. So, not only did they not object, But they invited the answer. They wanted the truth on that occasion. They wanted the truth from Dr. Kwesawai. They said, what you're saying is not true. They put that to Dr. Kwesawai. And he then testified that this is true. He testified, why would I say this if we did this and that? We left our bags there and so on and so forth. Why would I? No. So all that was at their own invitation. Now we have a witness who is testifying to the same matters, and now they are objecting to this witness testifying it. And this is why I stress that this is not an objection based on the lack of personal knowledge. It's not. And in fact, in their cross-examination, they sought, again, to make an issue of the fact that Dr. Kwesawai is not the person who spoke directly to the chairperson of the Fed. They sought to make much of that. Here is a witness who spoke directly to her. Can his testimony not be taken? On what grounds? They did not object. They actually... Now, I move on to 25. And my lords, this is, again, extremely pertinent, extremely relevant. The witness says, I returned to the strong room after my meeting with the chairperson of the EC and made it known to those present, including to the observers and other presidential candidate representatives and the EC strong room coordinator, that we had been sent to convey a message to the NDC presidential candidate. My colleague and I only left the premises of the Electoral Commission at the instance of the chairperson of the Electoral Commission to go and meet with the petitioner. We had absolutely no other reason to leave. We left our belongings, including computers and bags, in the strong room at the time we left. My colleague left his vehicle at the premises of the EC. Now, what has this testimony, what has it got to do with allegations of deceit or whatever? We left. We returned to the strong room after the meeting. I, the one who went and spoke to the person, I told everybody in the place that this is what happened. And then he goes on in paragraph 26, which is also being sought to be struck out. Paragraph 26 says, all of the above in paragraph 25, all this would not make sense if we did not intend to come back to the strong room. In fact, the second petitioner's witness also made similar statements. Why would he leave his stuff in there if he didn't intend to come back? And in the case of this particular witness, he says, he adds, again, a very pertinent, very relevant piece of information. He says, indeed, Mr. McMenu, who is representing the second respondent in this case, acknowledged in a television interview on Metro TV that he knew we were coming back, and said so to a colleague of ours who came to the strong room after we had left. Our colleague came specifically to give me a change of shirts I had requested for since we had been in the strong room from the evening of 7 December 2020. I attach here with a recording of that interview marked McMenu. My Lord,
not on the basis that they were not supported by the pleadings.
My Lord,
if my notes,
my Lord,
is right.
My Lord,
no, I just want to
to address. Yes. My Lord, I'm grateful for your guidance, because indeed my notes do not sufficiently capture all the points. So he claims that these are irrelevant.
Was it not the point that you missed? My Lord, I said
they were irrelevant and further not based on the pleadings. Further.
So, my lords, it was a double-barreled approach. And I think I dealt with the first barrel. I will deal with the second barrel. My lords, to claim that these statements or this testimony of the witness is irrelevant, I think, my lords, is difficult to appreciate in a context where, one, there is the evidence of Dr. Kwesa White already on record about the circumstances of their departure. That evidence is before you. And here's a witness who is not only corroborating that, but who is providing a further context of contemporaneous account, a contemporaneous account that is provided by the second respondent's representative. Well, my lords, as far as I can remember, admissions that are made by the other side are very important evidence when you are dealing especially with issues of credibility. Because if you are saying that this is what happened, counsel for first respondent cross-examination, it cannot have happened, it did not happen, you just sneaked away, you melted away, all kinds of words were used. The witness is saying that your second respondent's representative, he did an interview in which he acknowledged that was contemporaneous at that time. So there wouldn't be any lapses of memory or anything like that. He acknowledged that he knew that we were going to come back. And he boldly and truthfully, you know, and my Lord, we have to commend the truthfulness of Mr. McMenu.
At this stage,
Lord,
I think it goes to credibility.
Very well, very well, very well. I think that's about it. My Lord, I don't believe there was any other beyond 26. Right.
So those for 28. These two positions were not.
Right. So we are left with 29, 30, and 31. And maybe I will take, yes, I will also lump them together. And my recollection is that this was not double-barreled, but this was related to deceit. That's why this is where he tied it to 24 and said that you have to read it in conjunction with, yes, 24 to be read with 29, 30, 31. That's what my notes say. And my lords, my simple submission in one lumped up sentence is that these paragraphs are relevant testimony about issues in this matter on which the respondents are contesting what petitioner is saying, and they have nothing to do with an allegation of deceit. I'm sorry if it's too long a sentence already. I'm sure the professors don't like long sentences, but very well, very well, very well. And my lords will see that on the clear terms of those paragraphs, yet my colleague and I realized with shock on our reaching the residence of the petitioner that the EC chairperson was in the process of announcing results. These are just statements of facts. 30. Petitioner naturally asked so and so, then testified to the fact that he made attempts to reach and so on. And in conclusion, 31, he says, I still cannot believe and so on and so forth. And my lord, this again is regarding the credibility of the evidence that he's giving. He says, I cannot believe that because so and so. And he goes back, and my lord, this is very significant in paragraph 31, if I may say so. He says that since 1992, I have personally represented the NDC and its respective flag bearers in the strong room for various presidential elections. I have always played my part honestly and in a principled manner in election processes in the country, regardless of my own preferences, and been part of election outcomes in which my candidate won and where my candidate lost. My lord, that is again a witness who is using his experience in order to help this court to arrive at the truth. Now, my lord, paragraph 32 is not objected to. Yes. Oh, he's attacking paragraph. Okay, very well. So, my lord, I would respectfully just also underline the point that on many of these matters, evidence is already before you. And that evidence largely came out of cross-examination. That will be all.
Yes, on matters of law.
Yes, do you have any point of law to raise by way of reply?
Yes, my short reply is that we are in this position because of the magnanimity of the court that permitted the respondents to file their processes first before the petitioner.
No. You see, please. Is it a reply?
Yes, we
on point of law. Please. What happened was that they had discussions with you about the inability of this potential witness to give evidence.
No, my lord. Yes. No, they didn't have any discussions with us. My lords recall that when we came here on Wednesday, yes, I repeated exactly what you said, that they said they had a matter which they will come and discuss in court.
In chambers?
In chambers, sorry, my lords.
Yeah, but did they not discuss it with you?
No, my lords.
It wasn't mentioned?
No, my lords.
But this is not a reply. Oh, no, in fairness to the settled practice, this is not a reply. Yes, Mr.
My lords, I agree with my learned colleague on the other side that the rules under which petitions are brought do not make provision for reply, as he suggested. But that is the reason why, when you are filing your petition, you must put in all the relevant and material facts, because you know you will not have the opportunity of a reply. Now, my lords, all the paragraphs of the witness statement that we are taking objection to, in our view, relate to material facts, and there ought to have been a pleading of those facts in the petition. Then it will give the opportunity for them to elaborate those facts in their witness statement.
In fairness to the petitioners, you see, most of these depositions, arose out of the evidence of Dr. Pesa White.
But cross-examination. But my lord, but my lord, that actually shows that this witness statement is an attempt to close the problems of cross-examination.
Mr. Silfi, please.
In fact, at the heart of this
let's regulate
at the heart of this witness statement, is an attempt after the fact to bolster or correct some of the problems with Dr. Pesa White's thing. But that was not.
Was there no admission from Pesa White that he was there with this potential witness?
My lord, what we are saying is...
No. Respond to my question.
Yes, there was.
Yes.
But my lord, you notice that this witness would have given his evidence but for his sickness. But somehow, as soon as Dr. Pesa White finished his evidence in chief and was cross-examined, they brought him in. But that's beyond the point anyway. We got well. My lord, my main point is that these are major issues, and they ought, especially when the provisions under which petitions are brought do not make room for reply, they should have set those key issues. My lord, indeed, counsel has said in relation to paragraph 15, this is the word he used, these are material facts. That's what he said. When he was making, he forgot himself for that moment. He said, these are material facts that the court cannot ignore.
In some of their submissions,
yes.
The paragraphs of the petition, did you not state that some of these paragraphs, they don't have any validation in the petition?
Yes.
So it can be taken care of.
Yes.
It cannot be the subject of it.
Okay, my lord. So let me furthermore state. Two, in our view, significant statements of the law. First is that they are under an obligation under, as I indicated before, of the 11 Rule 12, that 12.1, subject to sub-rule 2, and my lord, sub-rule 2 is for purposes of this matter irrelevant because it deals with car accidents or something of the sort. Every pleading shall contain the necessary particulars of any claim or defense or other matter pleaded, including but without limitation to the generality of the foregoing. And then it talks about misrepresentation, fraud, and so on. So we are saying
this is not pleading.
We are not dealing with pleadings.
It's evidence.
There could have been formal application. You have some. Please bear with me. There could have been a formal application at your instance to seek the striking out of some of the paragraphs in the pleadings. We've gone beyond that.
Yes.
Evidence is being amassed. We are just assembling evidence for the determination of this case. And you drew attention to the fact that some of these paragraphs in the witness statements are not supported by the pleadings.
Yes.
That doesn't mean that you are attacking the pleading.
No.
There could be deficiencies in the pleadings, but that is normal. But that, you didn't attack the pleadings. So you cannot be referring us to
my lords,
the laws as they stand on pleadings.
No, my lords, my point here is that for them, for the petitioner to be able to say in his witness statement what we have in his witness statement, it must first point to paragraphs in his pleadings, and those paragraphs must provide particulars. If they don't, and then in their witness statement they throw these things at us because it claims it is relevant when it is not in his pleading, if the foundation is not in his pleading, it cannot be accepted. Especially when the rules require you to set your particulars. And my lords, we are not going to raise that.
Are very, very limited.
Yes. No, my lords, the provision makes a general statement that subject to paragraph 2, every pleading, that's what it says. Before then it goes on to say that especially in these cases, fraud, misrepresentation and so on. But the general clause is that subject to paragraph 2, which deals with particulars of debt, expenses or damages, or those particulars exceed 3 pages and so on. But subject to that, every pleading must have the particulars. And we are saying that their pleadings do not have the particulars that would enable them to lead this evidence. And my lords, again, we refer your lordships to.
Have you noticed any of this in the pleading of the first respondent?
My lords, in the first place, he has referred to certain paragraphs in the pleadings as the basis. I'm saying that those paragraphs should have, if they are referable, they should have had the particulars. Those paragraphs he referred to as giving him the foundation to lead this kind of evidence. If those paragraphs are actually relevant, they should have had particulars. That is the point we are making. There are no particulars. Please. Now, my lords, it's now going to be very difficult for me because it's a general thing. My lords, he refers to So, my lords, if you take, I believe, paragraph 23, which was one of them, the only particular referred to is that rather unusual way of exhibiting a document, Exhibit B. It has nothing to do with these matters. Yes, 23.
Yes.
Yes. Now, my lords, again, refer to Article 296.
Oh, that's the constitutional provision.
Yes, but
about discretion, exercise of discretion.
Yes, but he doesn't particularize. He's seeking to lead
the constitutional provision must be read as a whole. Yes. You don't have to particularize it.
No.
It must be read as a whole. If you are talking of Article 1. Yes. and it is in contention, you read it as a whole to appreciate whatever
but my lords, having raised the matter of violation of Article 296, as part of his pleading, in my view, he ought to have particularized what exactly were the violations. Yes, precisely. Yes.
So what does Article 296? What does it say? It is talking about discretion, fair exercise.
Yes.
That is all.
Yes.
So you look at it in the context. You look at it.
My lords, again, he that is all I can remember. My only final point is to refer your lordship. No, why not? I mentioned 23. I mentioned 24, which I think your lordships are not in agreement with. And I will my lords, I think my lords will see that there does not appear to be any pleading in respect of different summary sheets for the same region. There's nothing like that in his pleadings. There's not.
Ask any question about this Ayesu Ano.
My lord,
where they had two,
yes,
the second one sought to correct the first one.
Yes, my lord, I was then cross-examining Mr. Isiedun Ketia.
Yes.
And then I took him through his Exhibit D.
Yes.
And explained away Ayensuanu, which was in his Exhibit E.
Yes.
Yes.
Yes. But not Professor White. It was Mr. Isiedun Ketia, I remember.
That is so, it was Mr. Isiedun Ketia, not Professor White.
Yes. Now, well, that, as I said, I would like to refer your lordship to section 52A of the Evidence Act, which reads as follows. 52A of the Evidence Act. Yes, related to relevance, but the substantive thing is cumulative evidence. You know, the court, in its discretion, may exclude relevant evidence if the probative value of the evidence is substantially outweighed by considerations of undue delay, a waste of time, or needless presentation of cumulative evidence. My lord, the large portion of the paragraphs of the statement of witness statement we are sought to attack involve cumulative evidence. Yes. The large part of the paragraphs, cumulative evidence in relation to what Dr. Pesa White, the evidence that Dr. Pesa White had already given. And then uses it to fill the gaps in Dr. Pesa White's evidence or testimony. My Lord, we are done.
Our ruling.
All rise.
Galam se foto banyo. Sankofa yenchi. John Mahama nepe. Yenu yenwo sankofa. Sankofa yenchi. John Mahama nepe. Jafi Mahamo. John Mahama nepe. Jafi Mahamo. John Mahama nepe. Yenu yenwo John Mahama nepe. Yenu yenwo John Mahama nepe. Na yepe. Sankofa. Sankofa yenchi. John Mahama nepe. Sankofa yenchi. Sankofa yenchi. John Mahama nepe. Yenu yenwo sankofa. Sankofa yenchi. John Mahama nepe. Sankofa yenchi. Sankofa yenchi. John Mahama nepe. Sankofa. Sankofa yenchi. John Mahama nepe. Omanumo yedio. Omanumo mahamo. Asisa wajinyo. Ama odinada o. John Mahama nepe. Yanu yawo. Mahama nepe. Gana fari bro. Mahama nepe. Sanko. Sankofa. Sanko. Sankofa yenchi. Gana for. John Mahama nepe. Sanko. Sankofa. Sanko. Sankofa yenchi. Gana for. John Mahama nepe. Omanumo yedio. Omanumo mahamo. Asisa wajinyo. Ama odinada o. John Mahama nepe. Yanu yawo. Mahama nepe. Gana fari bro. Mahama nepe. Sanko. Sankofa. Sanko. Sankofa yenchi. Gana for. John Mahama nepe. Sanko. Sankofa. Sanko. Sankofa yenchi. Gana for. John Mahama nepe. Sankofa. Sankofa yenchi. Sanko. John Mahama nepe. Jama for me wo. Sanko. Sankofa yenchi. John Mahama nepe. Abu for me wo. Sankofa yenchi. John Mahama nepe. Jama for me wo. Sankofa yenchi. John Mahama nepe. Nobody for me wo. Sanko. Sankofa yenchi. John Mahama nepe. Awasi for me wo. Sanko. Sankofa yenchi. John Mahama nepe. Gana for mutina wa boy. Mahama mutina wa boy. Kekos for mutina wa boy. Mahama mutina wa boy. Sankofa. Sankofa yenchi. John Mahama nepe. Sankofa. Sankofa yenchi. John Mahama nepe. Yafi Mahamo. John Mahama nepe. Yenu yenwo. John Mahama nepe. Sankofa. Sankofa yenchi. John Mahama nepe. Yenu yenwo. John Mahama nepe. Yafi Mahamo. John Mahama nepe. Sankofa yenchi. Sankofa yenchi. John Mahama nepe. Yafi Mahamo. John Mahama nepe. Yenu yenwo. John Mahama nepe. Yenu yanki anya. John Mahama nepe. John Mahama nepe. Sisa mani yenwo. John Mahama nepe. Yenu yenwo. John Mahama nepe.
Ejo Bodo Tamalenku Doriansu Adewae Andisie Choma Mae Andisie Choma Mae Andisie Choma Mae Tena yanka Yeri ubesa pake kemu isenya yanka yedu besa pakemu rabeji enu rabeso yemu rabeji enu rabeso yemu na yebreo 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 na yebreo 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 na yebreo 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 na yebreo yebreo yebrepa rabeji enu rabeso yemu rabeji enu rabeso yemu ejo kodo anana nyumre ina bronco baby ni bejami tina mi huse groma efeba groma ye nice sekra ye fine ni bisayana yesi mahamane yeye wayadio Oshari jisu Oshe kotoka Sisi skuwadai Muma yempinine wayadio Yebezu Mahama yepeza Yebezu Zu Zu Yepeza Mahama enkasa Risa fedie Yehu Ey Yasuya ziyo Yasuya za fedie Yehu Nyamuodu Yebreo 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 Na yebreo 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 na yebreo 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 na yebreo yebreo yebrepa ejo kodo agbewae damunu wahi factions no wahi empty promises and wanna yati hey mahama bro dem bro wana bompo mahama bro dem bro ona mahama bro dem bro wana bompo mahama bro dem bro wana pu hecho wana pu kodo wana yebreo 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 na yebreo 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 na yebreo 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 na yebreo yebreo yebrepa rabeji yenu rabeso yemu rabeji yenu rabeso yemu mama fa 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 c'est fan Kojobi 2020 the Mahameba and the clear cause offer I go for the bar with a share 4 years but now so the end of one is 3 1 4 scan the bar watch your money from me a penny a bar said 2020 but soon near Tim Quem Abane the Mahama 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 2020 when you be on pre-cost Mahama Mahama Abane the Mahama 2020 when you be on pre Galam say was so be working oba na okofa soldiers wasi intimate na what is scaveters na what is low bed obegunu tell you betu enya bro am ya need to apa na pepa na say 2020 ba so ne yatim kwam abane de mahama fa 2020 when you be on pre-cost mahama fa abane de mahama fa 2020 when you be on pre share oba na obegu banks adena sare kan kra monti asie na bo beti maya manale nice maya mu kululu na mashasie kwase ya hwe nti aso mprenu mo beti na so de mo ye ne ye hu amoya ya any plenty 2020 lesson ye mo chance mahama fa 2020 when you be pre-cost mahama fa abane de mahama fa 2020 when you be pre share mama ye no mo se dollar adwane mo se mobile mo betena tenase mobile dollar na yan taban watu na onenam wiase Salam from you super incompetent. The American no full evidence. The bank na way, ofo na way. Yet in Kwama abane de Mahama fa 2020 when you be pre-cost Mahama fa abane de Mahama fa 2020
2020 when you be ampre. Kotokraba market wa yeah. Keletia market no wa yeah. Second overhead wa yeah. Mahama E-Blocks number 3SH Chesabasu Abane de Mahama 2020 when you be ampre cost Mahama Abane de Mahama 2020 when you be Abane de Jembra Abane de Jemafa Jembra Jembra can I deserve it? Abane de Mahama 2020 when you be ampre cost Mahama Abane de Mahama 2020 when you be ampre
Radio Unique 95.7 and across the 16 regions of this country, various regional and FM radio stations, and on Facebook, Ghana Broadcasting Corporation, waiting for the determination of those paragraphs that the second respondent raised as a form of objection to the witness statement of the third witness of the petitioner. So we're going to go through the paragraphs, and after that we'll engage our resources with our telephone. Starting off, paragraph 4 says that it is my understanding also that this is Mr. Rojo Metonunu's witness statement, and the blues we've taken here are the paragraphs that the second respondent has actually raised objection to, and that's what the court is going to determine whether to allow or not. Paragraph 4 says that it is my understanding also that the specific role of the chairperson of the EC as the sole returning officer is provided for in the Constitution and in the same regulation. And starting from here, that the second respondent raised issues. So starting from this particular line down, say, prior to her so-called declaration on 9 December 2020, the chairperson of the Electoral Commission did not perform the duty she was supposed to perform in order to be able to declare a winner of the election, as she attempted to do in the entire period after the election on 7th December 2020. She made a couple of brief visits to the strong room. There is issues also with paragraph 5. The EC had a video documentary person recording events in the strong room, and I have no doubt that if that documentary is available in its authentic version, it will confirm that I am saying, it will confirm what I am saying in this witness statement about things that occurred in the strong room. There is issues also with paragraph 6, and paragraph 6 says that dedicated fax machine printers and computers were provided for the strong room that were to receive fax from fax machines at the regional coalition centers in full view of agents of candidates, and then projected on an overhead projector in the strong room as the results were received. EC officials manned the fax machine on 9th December 2021 for, and well, we made some bit of correction here, so rather 9 December 2020. For many hours, the fax machine in the strong room were not working. One could see the frustration on the faces of many of the dedicated fax machine EC personnel. The fax transmission was also slowed. Then paragraph 7, instead of that pre-arranged transmission system for the regional collation sheets to be transmitted to the head office of the Electoral Commission, what happened part of the time was that one of the deputy director of the EC, with the name provided there, Dr. Siribokweku, would from time to time bring into the strong room what was claimed to be a regional coalition sheet. How he got that sheet was not disclosed. Also raised issues with paragraph 8. My colleague Dr. Tessa White and I on many occasions pointed out errors in figures and words on the sheet that were brought in, which ultimately affected the total and signed results. This sometimes led to the EC officials making phone calls on the basis of which they sought to explain and correct some of the things we pointed out. I cannot tell to whom those phone calls were made. I cannot tell if there were calls or if the calls were to EC officials or to some other people who were also involved in coalition process. This was there was no transparent process in this regard. And you remember, whilst the petitioner's lawyer was arguing this part, he had some bit of questions also coming from the bench there. Now, that's paragraph 9. Another paragraph that they had issues with. That's, for instance, when we pointed out problems on the Eastern region regional coalition sheet. Another one was subsequently brought in and claimed to be a corrected version. Obviously, that corrected version could not have been what was produced at the Regional Coalition Center at the time the coalition was done, and was therefore not an authentic document. The only way to establish the authenticity of that document was for the regional to be made available and a transparent process undertaken in the presence of agents of the correcting errors. The officials had already signed the regional summary sheet, and yet they accepted that correction were needed. And also at the time, at other times when we queried certain coalition results from the regional levels, they were quick to say, quote, once your representatives have signed, the only relief available is to go to court, unquote. Then paragraph 11, I must admit I was misled by this position of the EC officials into signing the regional coalition sheet for the Ashanti region simply because there was a signature of the agent of the petitioner at the Regional Coalition Center on the sheet. I later found out that from speaking with officials at the party headquarters that what had been presented on the signed coalition form was not consistent with a tally of polling station results in the Ashanti region. Paragraph 12. It is my express understanding that the entire election processes required, very importantly, a transparent assembling and collation of results so that no single vote of those who cast valid votes is left out of account, and not one invalid vote is included in the votes taken into account. It is also my understanding that nothing other than votes cast validly at one of the accredited 38,622 polling stations should be factored into the coalition at the 275 could be made in accordance with due process. So they skipped from 12 all the way to 15. So that means that paragraph 13 and paragraph 14, they had no issue. I mean, the second respondent had no issue with those paragraphs, so did not raise an objection. Now to paragraph 15 downwards, which an objection was also raised. And this one says that in respect of the Eastern region, 2 separate summary sheets were sent to the EC Stronghold. Both could not be authentic. Only by getting the originals of these documents can there be clarity on exactly which is the genuine form from the region. Then paragraph 16, in respect of Greater Accra region, we observe that the total votes given to the petitioner, which is meant to be based on the sum of all constituency votes on the face of the regional summary sheets presented, was less than his actual votes. We also observe that the regional summary sheet published by the EC while the process was ongoing had different figures compared to the one given to us in the National Coalition Center. Paragraph 17, there is a difference of 1,707 votes between the regional summary sheets presented to us in the strong room and the one published in the EC's or on the EC's website, and there has been no explanation for this. That was one of the things in respect of which we asked the party headquarters to have the election directorate go back to the polling station level and level data to ascertain what the correct figures were. We were waiting to get feedback on that, among other things, when we heard the declaration of the results by the chairperson of the Electoral Commission. Paragraph 18, in respect of the northern region, we observed 2 regional results summary sheets were brought into the National Coalition strong room. One was without signature of the agents for the candidates, and the second had no signature of the NDC agent for the region, but had signature of NPP, GUM, CPP and PPP. Only by getting the originals of these documents can there be clarity on exactly which is the genuine form from the region. Raised also issues. An objection was also raised on paragraph 19. On the Western Region summary sheets, the regional representative of the petitioner did not sign and gave the reasons for not signing. This was duly noted by the strong room representative and made a mistake when I signed the summary sheet in the EC strong room. At the time I signed, I missed the fact that the agents in the Regional Coalition Center had stated clearly the reason for not signing. We made the EC officials aware that the agents at the Regional Coalition Center had not signed and had given a reason for not signing. Then 20 would have pointed out my mistake to the chairperson of the Electoral Commission if she had come for the process of assembling and collating results as she was required to do. In that event, she never came. In any case, officials of the Electoral Commission, being aware of the reason given on the form by the agent of the petitioner for not signing, could not just disregard it and claim that once I had signed the summary sheet, the matter was closed. I'll leave it here. We'll quickly move back to the Supreme Court, and we'll be right back. Stay with us. Let's go to the Supreme Court.
All rise.
This is the ruling of the court. The second respondent counsel has raised objections to various paragraphs from the testimony of Robert Joseph Mertelnuno, PW3, in these proceedings. The relevant paragraphs, the subject of the objection, are from line 3 of paragraph 4, paragraphs 5, 6, 7, 8, 11, 16, 17, 19, 20, 22, 23, 24, 29, 30, and 31. Are objected to on the ground that they are not supported by the pleadings. Paragraph 9, 15, and 18 were objected to on the basis that they raise issues as to authenticity of documents in the election that the court has already dealt with. Paragraph 10 was objected to on the ground that the petitioner is seeking to build a new case. Paragraph 12, 25, and 26 are objected to as reflecting the opinion and irrelevant to the issues in controversy. Petitioner's counsel has argued that the objections are not supported in law because the testimony is premised on either the petition and the pleadings and the answers and prior testimony of the second witnesses, Dr. Pasa White, on the 3rd of February 2021, and the answer of the first respondent herein. We've considered the submissions of both counsel and the testimony and the pleadings in this petition. We are of the opinion that paragraphs 4, 5, 6, 7, and 18 ought to be struck out, and as they have no foundation in the pleadings or supported by the evidence, and the same is hereby struck out. Yes, the rest, that is the remaining paragraphs in the witness statement, are maintained. The petition is hereby adjourned to Monday, the 8th of February 2021 for cross-examination of PW3 at 9:30 a.m. So in fact, apart from paragraphs 4, 5, 6, 7, and 18, the rest of the paragraphs remain. Yes. Please, you have to prepare for your cross-examination when you come on Monday. We are coming at 9:30.
Bravo, my lords.
Yeah. Yeah.
My lords, we are most grateful.
Order in court, please. ayes.
specific role of the chairperson of the EC as the sole returning officer is provided for in the Constitution and in the same regulation prior to the so-called declaration on 9 December 2020. The chairperson of the Electoral Commission did not perform the duties she was supposed to perform in order to be able to declare a winner of the election, as she attempted to do. In the entire period after the election on 7 December 2020, she made a couple of very brief visits to the strong room. This has been struck out. Paragraph 5, the EC had a video documentary person recording events in the strong room, and I have no doubt that if that documentary is available in its authentic version, it will confirm what I'm saying in this witness statement about things that occurred in the strong room. Also taken out of the witness statement of Rojo Metal Nunu. 6 says that dedicated fax machine, printers and computers were provided for in a strong room that were to receive fax from fax machines, and the regional coalition center in full of view agents and that of the project also taken out. We'll come back to continue with the other paragraphs, but just for you to know, paragraph 4, 5, 6, 7 and 18 have been struck out. Let's move over back to the Supreme Court for the press conferences. We'll be right back. Stay with us.
Okay, good afternoon, ladies and gentlemen of the press. This morning, the petitioner presented his third witness in the person of Rojo Joseph Metal Nunu. And a witness statement prepared and signed by the said witness was filed before the court. And we were expecting that he was going to give his evidence today. The lawyers for the respondents, particularly the lawyers for the second respondent, Nanado Danko Akufado, raised a number of objections to the paragraphs of the witness statement. In fact, they raised objections to 23 out of 32 paragraphs of the witness statement. And the basic objection they raised was that those paragraphs, in terms of the evidence that was sought to be given, did not arise out of the pleadings of the petitioner. But, they sought to say that those paragraphs should have been reflected in the pleadings of the petitioner. However, a basic rule of law, which I'm sure was lost on them, is that in pleadings, you plead facts, but not evidence. And we had pleaded the facts that were necessary to ground our petition. And this witness statement was designed to provide evidence in support of the facts that we have pleaded. So, for instance, we made it clear in the petition that the chairperson of the Electoral Commission had acted in an unfair, arbitrary, and capricious manner. And the evidence of Rojo Metal Nunu, together with the evidence of Dr. Kwesa White, which I'm sure you witnessed the other day on the 3rd, was meant to make it clear the extent to which the chairperson was capricious, was arbitrary, and also unfair as far as the petitioner's case is concerned. And so we were taken aback when they sought to basically throw out the entire witness statement, saying that it was not supported by the pleadings. But as you have seen, I'm sure the court took a different view, and out of the 23 paragraphs in respect of which objection was taken, it was only 5 of them that the court said should be struck out. And for us, that is a great victory. We will not comment on the substantive content of the petition, of the witness statement, because it's yet to be cross-examined on them. And I'm sure on Monday, when we return to court, the cross-examination will take place. And thereafter, if there are any issues arising out of or in connection with the cross-examination, we'll address you and clarify those issues to your understanding. Any questions?
Doc, we previously asked about the impact that your witness statement being struck out will have on your case. In this particular instance, if you read the paragraphs 6 and 7, very serious allegations that once taken out, you should be worried about. It talks about fax machines not working and someone just walking into the strong room with documents coming from wherever and using it to collate results. I mean, you should be worried that such important piece of information is not going through this particular case.
Well, that is so. If you watched lead counsel, Mr. Tikata, on his feet, he made it very clear that in respect of paragraph 6 relating to the fax machines not working and people walking in with information or faxed documents and so on, that the evidence was meant to make clear that the systems that they had put in place, because remember that in first respondent's answer, the EC said they had put in place a seamless and transparent system for the collation of results. And paragraph 6 of the witness statement, which you correctly identified has been struck out, was meant to say that the system that you call seamless was in fact not seamless, that it was in fact dysfunctional, and that the fax machines were not working and there was frustration in the strong room. Of course, that is not the only evidence that we are providing. The rest of the paragraphs detail whatever took place in the strong room, and we think that ultimately, if those are taken into account, the probative value of what our witness will say will rise up. Any more questions?
Doc, you mentioned that what just happened is a great victory. I want to find out in what context are you speaking? What do you mean by great victory?
Pardon?
You mentioned that what just happened in court is a great victory to you. And I want to find out in what context are you speaking? What exactly do you mean by that?
Well, of course, if the objection was taken to almost the entire witness statement, if you watch Akodo-Ampah on his feet, he listed 23 out of 32 paragraphs to be struck out. Now, if you take those that remained, say paragraphs 1 to 3, those are just introductory paragraphs about who the witness is and so on and so forth. So basically, if the entire 23 paragraphs were struck out, then it would have meant that we would have basically an empty witness statement that would not be supportive of our case. But here's the case: we have only 5 out of the 23 being struck out, and for us, those 5 do not materially damage the case that we are seeking to make by bringing Rojo Metil-Nunu as a witness in this matter. So that is why I'm saying that it was a victory for the petitioner as far as we are concerned.
All right. Thank you very much. Forgive me for my ignorance, but I believe that the petitioner came to court to prove a point, the point being that neither of the 2 leading candidates attained more than 50% of the total votes cast. Now, the witnesses we've seen so far have spoken to other matters other than the figure 50% or less. Even today, the witness statements that we have seen does not address the issue of whether somebody attained 50% or less. Are you shifting the goalposts?
I don't think so. I don't think we are shifting the goalposts. And then, also, first of all, in his testimony, PW1, the General Secretary of our party, testified to the issue of whether or not any of the candidates crossed 50%, the 50% threshold as required under Article 63 of the Constitution. All right? And of course, you saw that they brought calculators and sought to get him to calculate figures, showing how many votes were won and so on and so forth. So that is what when we addressed you, we said that is the mathematics of Article 63. But this case is not only about the mathematics of Article 63. The case is also about the constitutionality of the conduct of the Electoral Commission, chairperson. And then also, more materially, about whether and the extent to which the declaration that she made is constitutional. Okay, that is an important point that we keep emphasizing, but it looks like there is an attempt in the media to reduce this case only to one issue that we have brought to court. It is not only one issue. There are weighty issues of law that the Supreme Court is being invited for the first time in the history of our constitutional democracy to determine. We underscore the point that this is the first time in the history of our democracy that a chairperson has declared, a president-elect based upon one set of figures, and then subsequently, repeatedly revise those figures. The question is, and I keep saying, can you put something on nothing and expect it to stand? It will not stand. And we are asking the court to declare that her conduct in terms of revision did not comport with law, did not comport with the Constitution, and therefore should be that declaration, together with the President-elect Declaration Instrument, CI 135, should be declared null and void and of no effect. And that has constitutional consequences. Of course, we cannot comment on the constitutional consequences because that is left to the court. But we are inviting the court to declare that her declaration, together with the instrument based upon which that declaration is now law, and for which reason Nana Addo Dankwa Akufo-Addo was sworn in as President of the Republic, are unconstitutional. That is an important point that you in the media must bear in mind. Any other questions?
Now, the last time when Dr. Kwesi White tested before the court, your colleagues on the other side were saying that if indeed Rojo was the one who the EC chair spoke to, he should come testify. Now he has come, and per the paragraphs that your colleagues on the other side were asking that be struck out, is there an indication that they will not be comfortable having Rojo testify before the court?
Well, that is a very obvious point, in the sense that they were saying Kwesi White, basically was giving hearsay evidence. Now, the person who was, in the strong room with him and who can corroborate what he is saying is being invited to give evidence. And the same people who said Rojo Metil-Nunu ought to have been called are now saying that he should not, be allowed to present evidence in full in respect of the facts that, of events that took place in the strong room. Now, I'll leave that to your judgment, and I wouldn't want to go beyond commenting on whether or not, the evidence that, he will give will corroborate what Kwesi White, provided to the court. All right, so.
Thank you. Let me do the chief. Okay. Yo, anyone, I say, and then you see our court in 8 hours. Anka enne anka ye dancing ya otosomi ensa anka oba begina adekan wakasa muhu se enam nsemsem binti anka ye no fa abefu fidie so na obia ahwe na TV so nanso eye yenuanom a ewo eye Nana Akufo-Addo ne lawyers esoro gina wo se ensem na ye dance dini no ode abetu dwa no ensem bebre wo mo mpesi yi firimu ti se mre bi se ne omo ye no se nsem omo ka nanu nso a eye Dr. Kwesi White ba no wo mo anomo ka se Dr. Kwesi White no no na oni isi kasa ye nti awo senka ne oni isi kasa ne na eba se ne oni isi kasa ne ankasa aba nso a mo so ne nsem na ode ba no eye eduasa miensa no omayi nkom pese yi eye eduonu miensa firimu eye eduasa mienu kom pese nke yi eduasa miensa firimu 23 na nso ko wie tire no Supreme Court say emu enum pe en obeye firimu ti minimum ka say 32 no a ye de baaye no emu enum epe en be firi so nti asamo e de baaye ni na ne dodo na nkasa ejina ne nanso a enye se we ntinyame ya dom na doade ye ba enne nipa no be wura daka mu na ne ye wo se o ka kire amanfo no wa ka kire amanfo imi da mase.
Our flag guys. So first I come back.
The protocol go
We didn't keep to the protocol. Which protocol? We said they were supposed to come in. We did first.
No, but you say that doesn't mean it's no. Okay. We are discussing. We are discussing. We are discussing. Colleagues, good afternoon. It's been a long day in court, and we have an opportunity to share with you a few remarks from our side as we wind down today's activities. As I mentioned, it's been long, but it's been a necessary exercise of going through some objections and then hearing the responses and having the court make a determination of what it would allow and what it would not allow in the witness statement. Let me start by recapping where we are in this trial and why we are here. The petitioner, Mr. John Dramani Mahama, former President of the Republic, invoked the jurisdiction of the Supreme Court, among other things, to say that based on the data contained in the declaration of the first respondent and the second respondent being declared as President-elect of the Republic of Ghana, no candidate will obtain more than 50% of the valid votes cast as required by Article 63(3). The petition also essentially makes the argument that the threshold of Article 63(3) was not met and that the declaration was in violation of Article 63(3). Goes on further to say that there were errors and mistakes and other things which will materially affect this election, and outlined 5 witnesses who would help adduce evidence to prove same. We all witnessed Mr. Johnson Asiedun Ketia come into the witness box and give testimony, and I think the jury is out on whether or not he was able to establish any of these things. And then we had Dr. Kwesa White take the witness box and mostly lead evidence to the effect that they considered that they were deceived by the EC chair to leave the strong room when the national or the presidential final results were being collated. Indeed, the word he used was that he was instructed, and subsequently he admitted that he cannot be instructed by the EC chair. Now, today, the petitioner introduced a third witness, Mr. Rojo Metil Nunu, who was one of those 2 in the strong room, who is the one that we were all expecting would take the witness box initially. And there were a number of paragraphs that he had outlined that he wanted to adduce before the court, some of which we objected to. In the end, the court upheld what we believe are some of the most substantial ones, paragraphs 4, 5, 6, 7, and 18. The court upheld those ones and struck it out. On Monday, we are coming in for cross-examination. Like they say, it's one thing putting something before the court, it's another thing defending it when it comes to cross-examination. And so, counsel on our side, and we believe counsel on the side of the first respondent, look forward to an opportunity on Monday to now put the paragraphs that have been admitted in Rojo's witness statement to the test under cross-examination. Essentially, that is what has happened today, as I'm sure you are aware. We are happy that finally Rojo will be in the witness box so that some very important questions can be put to him and the bench or the court can take judicial notice of whether or not those answers to those questions and those arguments that are being proffered go in any way to help deal with the issues before the court. And as I wrap up, let me take you through the issue. Sometimes when you follow the long conversations, you forget what the court is trying to answer. The court is answering 1 question of law, 3 questions of fact, and 1 question of law that arises as a result of a fact. The question of law is whether or not the petitioner in his petition has any reasonable cause of action. The questions of fact are whether or not, based on the data, nobody got 50%. Whether or not the Article 63(3) threshold was met is a question of law, as I've mentioned earlier. But whether or not you include or exclude Techim and South, does it change And then the other question of fact is whether or not all the so-called errors and vote padding affect the outcome of the presidential election results. The last question of law, which comes from fact, is whether or not the declaration will therefore be in violation of Article 63.3. If you find that at all material times Nana Akufo-Addo exceeded the 50% threshold, then that question of law will be answered in his favor, that then it was not unconstitutional. So we believe that we are making progress gradually. We are at a point where the third witness will be put in the box, and we'll see whether his argument stands up. What is interesting to note is that when our colleagues don't get a win in the wells of the Supreme Court, when they come, they say the decisions don't make sense, that the court is not being fair to them, etc. But today, you notice that as they got some of their arguments upheld, they seem to think that the court is the best so far. But we'll live to see what is out ahead of us. They describe it as a great victory. And let me explain to you why they describe it as a great victory. They describe it as a great victory because they realize that Dr. Kpetsahoi's testimony fell flat, could not stand the test of time. And therefore, they've tried to bring in Rojo, who initially they came with some reasons not to bring, so that he can. And if you listen to the argument of counsel for plaintiff, Mr. Chachuchi Kata, he makes the argument that during cross-examination, some very significant damage was made to the argument. And therefore, it is proper for them to bring in Rojo to try and re-establish some of those ones. So for them, if many of them had been struck out, it would be a very devastating day, because then it goes to buttress the point that where Rojo failed, where Kpesahoi failed, nobody can attempt to save him. Now, they seek to bring in Rojo to try and save Kpesahoi where he fell flat. And we are pleased that at least they are no longer trying to poison the minds of the public against the court. We look forward to what Monday will bring. We'll take your questions.
All right, so the first question I ask is that today in court, after lawyer for the petitioner finished his submissions, we saw the lawyer for the Electoral Commission, the first respondent, making an argument that it appears the court it seems to be going a certain direction in a petition, where they are allowing the petitioners to speak before the respondents, when it's supposed to be the petitioners first before the respondents. Is this something that you identify with as second respondents? Because I didn't hear your lawyer talk about it. Are you going to raise issues with it?
That's true. Well, let me quickly respond to that. What the counsel for the first respondent said was to draw the attention of the court to the fact that the procedure as it's unfolding, it appears to be deviating from the norm. The norm is that the petitioner makes his case first, and then the respondent responds. And even by CI 99, you are not allowed the opportunity of a reply. If you look at witness statements, for example, the petitioner refused the orders of the court to file the witness statement. What it meant was that the one responding rather put in his witness statement, as did the first respondent, and the petitioner then had opportunity to read it and attempt to now put in witness statements. So it's like the respondent is now going ahead and the petitioner is looking to how to close their gaps behind. In the case of calling witnesses, properly so called, you will notice that at the deadline for filing witness statements, Rojo Metelnunu's statement was never filed. They came to see the justices in chambers and made an application, which we didn't object to, because we believe there are some questions he must answer. But what has happened is that after Kpesahoi has been cross-examined and his case has fallen flat, then they bring in Rojo seeking to correct or salvage some parts of that case. It is that which the counsel for the first respondent is drawing the attention to the court, that is not the normal practice, and that they are literally allowing the petitioner to turn the rules upside down. I think it's obvious that the court is being very magnanimous. In fact, he used the word magnanimity. The court is being very magnanimous in hearing all sides and allowing things that ordinarily it will not allow. But, like we keep saying, always go back to the issues. What are the issues that the court is seeking to answer? And we are of the view that whatever things about fax machines not working, about phone call that they couldn't hear from, and then about deceit and a few other things, whether or not it changes 4751.2 or it changes the constitutionality of Article 63.3 is something that the bench will determine eventually.
Right.
I have this simple question. Yes, that was on Wednesday. You asked.
You have to
said
speak up, sir, so that we can hear you.
on Wednesday you said that the court is a place of law, and then on your previous interviews you also made a statement that justice is denial of justice is delayed of justice. Or I don't know.
No, I haven't said that.
Delayed. Yes, exactly. Sorry. And so with that, putting law and justice together, if each of them is contradicting each other, which one do you choose? Law over justice or justice over law?
Well, in the end, the court seeks to do justice and seeks to do it in accordance with law. Justice must be done, but justice must be done in accordance with law. You cannot do justice outside the law. That would be extrajudicial attempts to establish justice. We've had a history in our country where some people have elected that they don't want to do things in accordance with the law. They have executed people without due process. They have confiscated properties without due process. We have now come into a democratic era. So everything, including justice, the rule of law, is hinged on the Constitution and is hinged on law. So justice is what we expect to be done in this manner, or in this matter, and we expect that it will be done in accordance with law. That is why whatever prayers we have, we'll say it before the court, they will rise, think through it, and then they will come back. What we must not do is to bastardize the courts when we don't get our way. And that's why I made the point that you notice that our friends, when they don't get their prayers upheld, they come here and they say it doesn't make sense. They are not being fair. Today, when some of the arguments are upheld, they literally say that the court is the best court that they have seen. We must be consistent. We've been consistent from day one, that we are in the hands of the court. Yes, sir.
In terms of what transpired today, there are some who look at it and say that your side should be concerned in that the 18 issues that went through were matters that effectively came up during cross-examination. Unfortunately for your side, you've already filed your witness statement. You would only have the opportunity to re-examine your witness and cross-examine the other witnesses. It means that you will not have the window of opportunity to put through and respond to some of the issues that may come up during cross-examination like they had in this particular instance. I mean, that should be of concern to your side.
Well, not exactly. Let me explain to you why. First of all, where are we in this process? We are at a point where the petitioner is still trying to establish his case. The petitioner has not established his case or has not told the court that they have closed their case, that they believe they have substantively made a case before the court. What they've done is to make some pleadings and call two witnesses so far, Johnson Esiedun Ketia, the General Secretary and the coordinator of the entire electoral program, who came in, calculator in hand, he ended up with 4751. 4751, plus or minus Techima and South, 4751. You never saw him calculate and say, nobody got 50%. Then they moved on to Pesa White, and you were wondering whether he will also come and perhaps be the one to provide the evidence that will show that nobody won. Because remember, they have told the millions of their supporters across this country that they won. Many of them believed them, got on the streets. They came to court now, they say they didn't win, but nobody won. So at least you were expecting that one of their witnesses will prove that nobody won, even if you forgive them for the first exercise of deceit of the Ghanaian public and their supporters. Pesa White gets into the box, and the gravamen of his testimony is that they were deceived by the EC chair. He uses the word instruct to leave. And at the end of his testimony, one question from Counsel Akoto Ampao, I put it to you that you cannot be instructed to leave, he admits, and the whole testimony crumbles. So now you find that they go and bring our very good friend Rojo Metununu, who we were all hoping they will put in the witness box in the very first case, because he was the one granting the TV interviews and claiming in those interviews some things, which I won't say now because cross-examination hasn't started. They are now at a point where they are trying to make their case. It is when they succeed in making a case and tell the court that, my lord, we have closed our case, that a certain threshold may or may not have been met, in which instance we and the first respondents may have an obligation to also open or advance a case. So it's early days yet. Bear in mind that they have made some specific allegations out there. They have to prove it in the court of law. Until then, we don't even have a case so much to make. We are ready. Chairman McMahon comes every day with his pink sheets and his regional coalition sheets and his Form 12s. and is ready that if it becomes necessary that he mounts the witness box and prove that Nana Akufo-Addo indeed got 51.2 and beyond, he's happy to do it. But they have to prove their case first, because he who alleges must prove. Check section 14, section 17 of the Evidence Act. So Rojo will have to now come into the box, make his allegations, prove same, and be cross-examined on it before we move to the next steps.
Your side during Dr. Kwesi White's cross-examination indicated that the petitioner couldn't have brought Roger Metinunu because there was no way he was coming to be able to confirm what Kwesi White was saying. Now, today, your side made an attempt to almost take out the paragraphs in Roger Metinunu's witness statement. Now, you are saying that you are happy Roger Metinunu is coming. How do you link these two to you saying that you are happy that Roger Metinunu is coming to
First of all, let me show you what is interesting. There are supposedly two people who have been sent to go and protect the interest of Mr. John Dramani Mahama at the EC Strong Room. Person one is the principal party. Person two is more or less the supporting actor. Person one goes to have a conversation and supposedly reports to person two that both of them should leave. And at the material time when the petitioner wants to adduce this evidence, he opts to bring person two and says person one should come and corroborate. Anybody who is following it begins to realize that something funny is going on here. Because ideally you will bring in Rojo and then rather look to get somebody to corroborate, assuming his evidence is not enough. They flipped it the other way around, no wahala. But we are happy to have Rojo in the box because there are some questions that will be put to him. That is why on the other day were saying that perhaps they didn't bring him because they were of the view that if he comes, he will perjure himself. Now he has come, he has tendered in his witness statement. The technicalities of what must be accepted and what doesn't meet the standard have been dispatched with. Now the questions are going to be put to him to see whether his argument, what they tell the NDC supporters, what he told the supporters, whether I can stand the test of scrutiny in court. And that's why we're very pleased at where we are. Remember, a case is now being made, and we are now at the point where we are cross-examining that case. When it is done, if we have to now get into a full response, then we'll get into it. I want to say thank you and invite my colleague Fatih to sum up in Twi for us.
Honorable Kojo Ponkroma, Minister Designate, Eddie Abreno, Ehubehia say, Mebono Tofa or Akankasem.